me from my winter hell. I've got candles and candy, I can be your daddy if you only let me creep into your prison cell. Hey baby, can you tell I'm not a criminal? Your choice is seminal. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. Just speak low, stand in your row, try not to show this life's a show. Try not to glow way down below. Oh, it's a lot of woe, and that's not a place where you would like to go. I've got cigarettes and brandy, which could come in handy if you just help me loosen up my hand grenades fuse. Baby, don't refuse my truth, but it's up to you now to choose. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true, 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 true,
All right, let me get us right back around a little bit because I'm not sure where it started buffering. I'm sorry, you guys, about that. I don't know what that's about. It's very frustrating. But thank you guys for coming back. I appreciate that very much. Here we go. Let me fix this. Yep, let's get right back. Oh, right back into it. Here you go.
Oh my God. Oh my God. What just happened? Oh, I got so many things. I told him, let me sleep up there. You sleep here because this door doesn't lock and that door does.
Let me sleep up there because this door doesn't lock and that door does. Correct?
Yes.
And she means, of course, that downstairs master bedroom. Correct?
It can be assumed.
Because that one doesn't lock. Right?
Yes.
The bedroom that locks is upstairs. And she says, let me sleep up there because this door doesn't lock and that door does. Go ahead and roll, Chris.
He told me not to close my eyes. I should have just got my car and left. But I got that stupid device thing on it. Oh, God.
I should have got into my car and left, but I have that stupid device thing on it. Correct?
That is a statement again with, yes.
Oh,
And you
chicken
know
lady,
from your
hold on.
investigation, what
Chicken lady says, Jen, I have to tell you that I would not listen to this caterwauling again for just anyone. Let that be a testament to my loyalty to you. I appreciate it. Thank you so much, chicken lady. I wouldn't listen to this caterwauling again because this now will be the third time, fourth time. I don't even know because I've already watched this. I've already watched this day for anybody but you guys. Glad we all are loyal to one another. Look, bro, you're not really making any points, and I don't give a rat's fat kneecap how many times you write shit down on that little handy dandy notebook of yours. You're cherry picking statements, and all you're getting the detective on the stand to say is, yeah, she said it. Well, we know she said it. I mean, we hear her. We can hear what she said. That doesn't make it so.
she's referring to is an ignition interlock device.
Yes.
Correct? The Porsche that she owns is fitted with an ignition interlock device related to the 215-216 arrest for the DUI.
Yes.
Thank you, Kentucky Lee. Kentucky Lee says it's okay. Who knows? Maybe it's on your end, but definitely not your fault, Jen. I'm just happy you're back. I'm a ride or die, you know? Props everyone here. Well, thanks, babe. I appreciate it very, very much. I don't know what it is. It's sometimes Streamlabs just dumps streams and I don't get it. Like they just hit me. Look, I just paid them too. It just literally came out like 2 seconds ago.
When a person has consumed any amount of alcohol and they get into a vehicle with an ignition interlock switch and they try to start it by blowing into it, it won't work. Correct?
Yes.
They're designed to not function if you've got alcohol in your breath.
Yes. I know.
And that's what's in her car.
Yes. Yes.
I mean, true. She did say that she had been drinking. There was some hours in between, but whatevs. I get it. You don't want to take the chance. Okay. So that's great, but you can walk. She was in good shape. She was a runner.
Now, 105.23, Chris. Up until 105.23, she does not know his condition despite repeated requests to find out what the condition was. But at 105.23, you would agree she is told, and we'll go ahead and watch it, then I'll finish my question, okay? You're at 105.18, that's fine.
If I should just drop down there.
He was alive.
When they left here, yes.
Oh my God, thank God.
First thing out.
Okay, 105.23, thereabouts, she's told very directly, when they left here, yes, meaning he was alive. True?
That is what the statement is. Yes.
And you're not aware of a later statement by anybody until the one that you made
Yes.
in the interview room hours later, at the very end of the interview, telling her, or close to the end, telling her he was deceased.
Yes, because like I said, the reason I did not tell her this the whole time is I knew the emotional aspect of the interview would be over, as which it was.
You didn't tell her because you knew that the emotional aspect would end your ability to interview. Right?
Yes, therefore the theatrics of it, yes, the up and down, up and down.
One 132:58, Chris. Let's go 137:58. I'm sorry, 137:58.
When he got mad at me, I should have just left, but I was scared because the last time he got mad at me, and I left, and I was so upset.
This is again a reference to the DUI night, true?
Yes.
But it's not consistent with this note that we have in the phone.
No, but there's no time relevance of when he was mad. It could have been to the DUI, it could have been, that's the way I read this.
No, you just said this is in reference to the DUI. Earlier you said, I don't think she was talking about it, but you just said it was in reference to the DUI, what she's talking about here.
The statement earlier, I was referencing, I think she was talking about that night, but earlier about the DUI. This statement here, he got mad at me, I should have left, but I was scared, which was referencing this night here, what I believe. Because the last time he got mad at me and I left, I was so upset.
Yeah.
That was this time. But keep in mind, the statements are so inconsistent here because there's...
Okay. We'll just agree that her version, if she's talking about the DUI, is not consistent with the note. True?
I cannot agree with that.
You think it is consistent with the note?
I think you're pulling two very different things and trying to make me agree to correlate on one thing.
What I'm asking you is the note consistent with her version of the DUI that she gives at least twice so far? And again, later, we're going to talk about the DUI.
One note is a lot more detailed, the note that you're speaking of. These are just statements on the front porch that you're asking me to derive an opinion about when I cannot do that because she's talking about this night, then mentions other times.
Okay. All right. I want to talk to you now about the interview. Okay?
Yes, sir.
I think that is defendant, I'm sorry, that's State's Exhibit. Is it 1 or 2? What is your interview? State's
It is 219.
219. Oh, got it. Now we're going to have to get out of that, but I have to tell it to, unplug it. I can't do it. I want to eject this one. If I go and, can you get back on the screen and do it? Is it? You want to take out what's on the mouse now? I have to tell it to eject. There you go.
Hold on. Oh my gosh, that's fantastic news, Jonah's mom. I know you've been waiting so long and so patiently for this. I'm so happy for you. That's fantastic news. Congratulations, babe. Yes, chicken lady, this lawyer is annoying. However, I do appreciate his lack of objections so far. I do as well. But here's the thing. I understand what he's trying to do. He's trying to get the jury to understand that there were reasons why she couldn't leave. Okay. And it is true, if you have one of those devices on your car that you have to breathe into every time before you drive and you're upset, you might not be able to do it. You've on top of which you have alcohol, so it may not even let you start your car. I get it. Okay. There were some obstacles. All right. Why she couldn't just leave. That's not going to get us over the hump of why she shot at him through a door. It's just not. Because once he retreated, and that is why I think the prosecutor continues to use that word. Once he retreated behind the door and locked it, the threat ceased to exist. The imminent threat, I should say. Even if you believe every word that came out of her mouth about all the things that he did that night, right? The imminent threat was over. At that point, she had a decision to make. She could have gotten her firearm and she could have left the house. She could have done that. Instead, she went to confront him about the phone, according to her. I'm not even so sure that dadgum phone was in that bedroom, if I'm being honest. I still am not sure about that.
And we'll go 219. Good deal. All right.
What are we doing, guys? What's happening here? Uh-oh, technical difficulties.
Let's go to
Let's kick this up a notch, shall we?
page 6. It started at
We're going to go to 1.5. If that's too fast for you guys, let me know.
3502. Don't roll it till I say okay. Close it. I want to talk to you now while we're getting this going about your experience as a police officer and your training and all those things, okay? You would agree with me if I was to say this was your first homicide case
So,
ever been the lead on?
actually, when I was speaking, I was talking murder, not homicide. No, I worked in voluntary homicide, stuff like that. I was thinking murder while we were talking. I've had
mean-
times since then
At this time, this was your first homicide/murder case that you'd ever worked.
where the murder warrant was taken.
So that's a yes, correct?
Yes, as lead.
It's your first case on a homicide, and of course you rely on your training when you're doing that, when you're working a case. And you've had training dating back to 2013 when you first started as a jailer.
Yes.
And every year you go back for more training.
Yes.
That's part of what it is to be a police officer.
Yes.
And as far as training related to firearms, you'd agree you've got a lot of that.
Naturally, yes.
2016, you took the firearms and use of deadly force as a 4-hour course. You took low-light firearm skills in 2016.
Should have done it every year, so.
Well, and we'll talk about that in a second, but you took shotgun as well, which is a separate course just about shotguns.
Yes.
Another firearms use of deadly force in 2017. Sound right?
Is that the 1 hour course that we're talking, 2 hour course?
2 hour
Yeah, so that's the state required use of force class and annual qualification. It's going to happen every year, yes.
You took a 16-hour patrol rifle course. You took another patrol rifle course for 2 hours that same year. Sound right?
If it's on my post, I'm sure it's correct, yes.
So I'll approach and show you just because I don't want you to guess, okay? Approach witness.
So yes, there's been firearms training every year. Yeah,
There's patrol rifle.
I mean, it keeps going, yes.
Oh, yeah, it does. And low-light firearms training again. You took a firearms requalification for 2 hours in 2018. Sound right?
It's annual.
May I just stand up here so you can actually view the record, Judge? May I approach?
Here.
I'm not trying to hide something.
No, yes, it's annual qualification stuff. Most of that stuff is.
2 hours requalification in 2018, right? 2 hours requalification use of deadly force in 2018. And then you got
Oh, yes,
ambush survival tactics, 16 hours in 2018.
yes,
Shotgun, 2 hours in 2018.
yes,
Patrol rifle, another 2 hours in 2018.
yes,
2 hours in firearms requalification use of deadly force in 2019.
yes,
Advanced pistol tactics, 8 hours in 2019.
yes,
2 hour shotgun in 2018.
yes, yes,
2 hours patrol rifle requalification.
yes,
2 hours low light firearms training.
yes,
Then in 2020, we've got firearms requalification and use of deadly force, 4 hours.
yes,
2 hours low-light firearms training, right?
Yes.
2020, 1 hour backup weapon training.
Yes, that was qualification on the backup.
Still in we're in 2021, I'm sorry. Firearms requalification, use of deadly force, 2 hours.
Yes, annual.
1 hour firearms requalification, 2021.
Yes.
1 other hour of patrol rifle qualification.
Bro,
1 hour firearms training in 2021.
he knows how to handle a firearm. We get it. What is your point?
Yes.
1 hour firearms training. It says not requalification, and also in 2021.
Yes.
Then we're in
Hold on.
2022, another hour of firearms training,
Yes.
and then a firearms requalification, another hour.
Yes.
2022 still, another firearms training for an hour.
Yes.
Not a requalification, another firearms training, 2022 for an hour.
Yes.
Hold on a minute. I need a moment. I need a moment. Do y'all need a moment?
Oh my God, who the hell cares?
Another firearms training in 2022.
Yes.
Not a requalification. Then another hour in firearms training in 2022. Then 8 hours in tactical firearm skills in 2022.
Yes.
Looks like you took SWAT training twice, which was 8 hours apiece for 16 hours.
Those aren't just firearms or tactics also, yes.
Okay. Low light firearms training again, 1 hour, and another low light firearms training 1 hour in 2022. Then we're in 2023, another firearms training, not requalification, 2023.
Yeah, I just want to, just my post tracker, I was curious about one thing where you want this.
I'll let you know.
No, that's fine, you're good. It's 2:30, yes.
Still on 2023. Firearms requalification, 1 hour. Correct?
Yes.
Then another forearm firearm training, 2023.
Yes.
Then an hour on use of deadly force.
Yes.
16 hours on SWAT training in
Yes.
2023. Another firearms training in 2023 for an hour. Then another hour in firearms training in 2023.
Yes.
Then another hour in firearms requalification.
Yes.
Then you took combat shooting skills for an hour.
Yes.
Then backup weapons qualification for an
Yes.
hour. Then firearms requalification for an hour. Then another low light firearms training for an hour.
Yes.
And then subdued lighting firearms requalification for an hour.
Yes.
Then we're at patrol rifle qualification for an hour.
Yes.
Backup weapon qualification for an hour.
Yes.
And another 8 hours on use of deadly force.
Yes.
Now we're into 2024. We got 1 hour on firearms requalification.
Yes.
1 hour on combat shooting skills.
Yes.
Another hour on low light firearms training.
Yes.
Another hour on subdued lighting firearms requalification.
Yes.
Another hour on patrol rifle qualification.
Annual qualification, yes.
And then another hour on shotgun qualification.
Correct, yes.
And then 12 hours on use of deadly force.
Okay, yeah, that's not technically firearms, but
Okay.
yes.
Oh my God, who the hell cares?
Yes.
Now we're into 2025. Firearms requalification, 1 hour. Subdued lighting firearms requalification for 1 hour.
Yes.
Low light firearms training for an hour.
Yes.
Another 4 hours low light firearms training. 1 hour backup weapon qualification.
Yes.
8 hours on tactical shotgun. Correct?
Yes, I was thinking about the course, yes. I believe that was it.
I don't know how many hours that is, but it's a lot.
There's, in perspective, though, there's a lot that skipped over in that as far as other training diversities.
Exactly. I want to talk to you about the number of times and the number of hours you've taken on domestic violence investigation. Okay? We see 1 hour in 2016. See
Yes.
that? See that?
I was just looking above to make sure, yes.
And we see 1 more hour in 2021. 2 hours total. Correct? Correct.
I guess it seems like I've had a lot more than that, but
Okay. We'll look through it.
no, I'm good.
You are on now your first murder.
Okay, so everybody, just so you know, I guess the point was that he's overqualified in firearms, underqualified in domestic violence. That's the point that we finally derived at 7 years. Like, I started out the day with Nuggie, and she was just a little 5-year-old. Now she's graduated high school. She's off in college and working. Jesus.
Case where you are the lead detective. You have the suspect in the room with you, and you know she has made statements about being afraid that he might kill her. She has nodded to being so scared, whether there's prior violence. She said yes, or nodded her head. She said, I thought he was going to kill me. She has said, if he said don't go to sleep, she has said, I was going to leave and I was scared. He got mad when I was going to move forward. If I moved on, he would kill me. He would shove that gun down my throat. She's asked if she can sleep in the upstairs room that locks, and she's expressed concern about being able to leave in the car. And she's been checked out by EMS, right?
Yes.
She has elevated blood pressure, and they're telling the officers there she needs to go to the hospital and get checked out.
But you're confused.
I'm sorry?
She refused.
Correct, she didn't want to go, right? Nobody's fault. She didn't want to go. True?
Correct.
The thing she wants to know more than anything is whether he's alive or dead. Agreed?
She keeps asking.
She didn't ask for anything more than that. That was the number one request, right?
Yes.
And she comes into the interview room with you, and you don't want to give her that information. You said, I didn't tell her because I knew the emotional aspects would end the interview.
Yes, the theatrics of it, yes.
And then, good roll. We're starting at 3458? 3458.
Hey, do you know his? You know his passcode?
Yeah, you don't want me to.
Okay. All right. So you're here, and it's very important to me that you're here. You already said some stuff about why you're here, and that really has me interested. I really want to know everything. Everything. But before you can tell me that, because I have you here, and you don't know the way out of the building. Like I said, I want to read something to you, okay? But I just want to preface what you have to tell me is very important, okay? So it's basic stuff you've heard before. You're not under arrest. It's just circumstantial stuff, okay? You have the right to remain silent. Anything you say can be used against you in the court of law. You have the right to talk to a lawyer and have him present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you for any question if you wish. You can decide anytime to exercise these rights and not answer any questions or make any statements. But I'm going to preface that with what you have to say is very important to me.
So should I get a lawyer?
Right now, you have no reason to have one. But what you say is very important to me.
Just, I told you, it's just been a bad experience here since I moved here.
Once we initially just sign right, place your name right here. Just write your name, however you write it. And then just your initials. I can't for you. Hold your glasses. Just initial those. That's each bullet point. You can reread it. Same thing I said. You place your name on the bottom. Thank you. And
As a police officer, one of the things that's important to you is people's constitutional rights.
yes.
You know that those are important and they're things that you take seriously.
Yes.
You want to make sure that everybody who comes into an interview with you knows what their rights are
Yes.
and that they have been told what their rights are
Yes.
and that they're given an opportunity to exercise those rights.
Yes.
And your sheriff's office, in addition to the constitutional rights, has rules about advising people about their constitutional rights.
Yes.
And you have a pre-printed form that you're asked to use in these sorts of situations.
Yes.
The form has each one of the individual rights
Yes.
listed
Yes. We've seen the form.
and a place for everybody to initial
Yes.
for each individual right, correct?
Yes.
And then at the bottom, it also provides a place for a signature, correct?
Yes.
And there's a space for you to initial all the rights that shows that you understand them, correct?
Yes.
And you even encouraged her to initial those things, right?
Yes.
You said, go ahead and initial those, indicating you understand, right?
Yes.
And then you just handed her the form and said, just go ahead and sign. Just sign right there at the bottom.
Place your name. Yes.
You know that there are things during an interview like this that a lawyer could be of assistance to a suspect with.
Yes.
That's why the rights are there. You can have a lawyer with you while you're being questioned, right?
Yes.
You know that if a lawyer was to come in there, they might first of all say, this is not a person in an emotional state to be interviewed right now. True?
Hypothetically, in that, yes.
Hypothetically, yes. They might say, hey, have you already been to the hospital and found out that this man is dead before this interview starts? They might find that out and tell her, hey, he's dead. This man is deceased. They're investigating you for murder, right?
Yes. I mean,
But you didn't want her to have that information because you knew the emotional aspects of it would end the interview, right?
I'll just answer the point blank question without any rebuttal, but yes.
If somebody is living in absolute terror of someone else, and they believe deep in their heart that this person is still alive, do you think that they're going to tell you all the things that he's done to them in an interview like this?
I mean, Judge, I'm going to object. That calls for speculation. I don't even know how Investigator Member can be answering these types of questions. He's asking for Investigator Member to speculate about what other people might be thinking or how other people might react in a situation.
It's not speculative.
So,
I'll sustain the objection, but I'll allow you to ask it in a little bit different way.
You wanted to get information from her that was correct, didn't you?
yes.
You wanted to get information that was truthful, right?
Absolutely.
You wanted to make her feel comfortable in the interview. You said use the word rapport earlier, remember that?
Yes, and even have female in there.
Even had your female in there
Yes.
to make her feel comfortable, right?
Yes.
So that you could get accurate and correct information. right?
It was a hope.
Yes. If someone's afraid, they may not tell you the truth. You would agree with that?
Objection, speculation, calls for speculation.
Overruled.
I was saying cases, but I've also seen the other one. It goes both ways. I cannot hang on that statement and give you an accurate answer.
You can't give me an accurate answer.
I can see where somebody would, but then I can also think of instances where somebody does tell the truth. So it's speculative, yes.
Okay. Even when somebody's terrified of someone, you've had situations where they've told you the truth. Is that what you're saying?
Re-ask the question.
Even in situations where someone's terrified of another person,
Yes.
they've still told you the truth.
Yes.
And that's true in every case?
Well, we'll go to this. Look at the crimes against children cases. These kids sexually abused by people in their household, they still come forward and tell the truth. You know they're terrified. There's a risk they have to go home with these people.
Well, that's pretty interesting now, isn't it? Because usually what they do is they say maybe one thing. They call it an outcry, don't they?
Initially, then we go to the forensic interview.
Yeah, initially they just say one little thing, and then they have to go and sit with a psychologist in one of those rooms that has all the pictures all over the wall,
No,
right?
incorrect. The
That's not
forensic
where they
interview is not a psychologist. She can be trained in psychology, but they're just,
Okay.
I'm just telling you from the Edmonds Telephone Center, and it's not a room with pictures. It's,
Don't they tell you that disclosure from a child is a process, meaning you only get a little bit at the beginning, and then over time it gets more and more and more?
yes.
Right. You might get a little at the beginning, even though they're in a room safe, but over time they tell more and more and more and more, right?
But yes.
Why did you think she wanted to know so badly that he was alive or dead?
Truthfully?
Yes, sir.
Because she had altered the scene. She was trying to get with a story to stick with, and she could not make up her mind of what she was going to say.
She had altered the scene. She was trying to come up with a story to stick with. And whether he's alive or dead changes how she's going to tell the story.
Believe if it's her word against somebody else's, yes.
It might change what she tells you about what he had done to her. Would you agree?
Hypothetically.
Hypothetically, for sure. Well, let's just start. Let's just go right into the interview and talk about the very first thing that she starts telling you about. The very first thing is the DUI arrest, right? Go ahead, roll.
Well, bad experience.
Well, it was Valentine's weekend, and we got in a fight about the same thing that we got in a fight about tonight. And I ended up getting a DUI. I left. We got a big fight, and he told me to leave, or he was going to hurt me. And I tried to talk to him and tell him I didn't want to go, and just let it be. And he sat on the steps and told me to go. And I did have some drinks that night, but it was like 6 something, because we were working all day. I fell asleep about 5. I had a drink at 6 after I didn't drink it all. Then we went to dinner, and I had about a drink and a half there. And we went home. And then we watched a movie, and the movie probably lasted until like 11, and then he fell asleep in the chair. And I got up to my medicine at night, my medicine, and I looked right, and I took a half, like a half a minute, and then I lay down.
There it is, right there. See, he was asleep until 11 o'clock. So why was she searching the Hall County Sheriff's Department at 10 o'clock? What was that about, ma'am?
And I couldn't go to sleep because we had a big fight, and then he came, after I got all that, he came in there.
Let's hear that again, okay?
Went to dinner, and I had about a drink and a half there, and we went home. And then we watched a movie, and the movie probably lasted until like 11, and then he fell asleep in the chair. And I got up to my medicine at night, my medicine, and I looked right, and I took a half a minute, and then I lay down, and I couldn't go to sleep because we had a big fight, and then he came, after I got all that, he came in there, and we got in a huge fight. And then, like he did again, he was going to go up the stairs, and so I went upstairs. He said, I lay there for about 3 hours, couldn't go to sleep, so I thought I was going to go on St. Simon's, because I usually get up I usually leave between 3 and 4 anyway. And so I got up, and got dressed, and got all my stuff and put it in my car, and then I went upstairs and he had the door locked. I knocked the door, and I said I was leaving, and then I got the rest of my stuff and put it in the car. So I walked back in, and I was going to tell him goodbye, and he was sitting on the steps, on the second flight of steps. And he said, good.
This sounds incredibly close to the DUI note that's in the phone. Wouldn't you agree?
May I see them?
Yeah. I'll tell you what, I'll read it to you. You tell me, okay? David had fallen asleep watching TV. I got up and turned off the TV and fireplace. David woke up. He headed to the bedroom, and I started talking to him to solve the argument. He did not wish to discuss, and he headed upstairs around 1:30 a.m. I lied in bed for several hours. I could not fall asleep. I read a few articles and organized my thoughts in my journal. Around 3 a.m., I decided to leave an hour early. I packed my belongings and put them inside of my car, my vehicle. When I came back inside, David was awake and on the stairs, and we talked for 20 minutes, and I left to head home. Pretty close.
Like practice, yes.
Pretty darn close. The rehearsed note in the phone sounds almost identical to what she tells you in this interview. What do you make of that?
You're the one that said rehearsed. She said it quote for quote back to me, I guess.
Okay. Let's go to 4247, Chris.
Hold on a minute. So is the story that she's relaying in the interrogation video from the DUI night in January? Or is it from the night in March, the night she shot him? I'm so confused. And if I'm confused, the jury's probably confused too.
We're at 4246.
We're fighting about when I met him in April. I had just broke up with a boyfriend like in February or whatever.
Are you at 4247? Oh, I think we come back a little bit further. Just a little bit beyond 4247. Go to 4240. 4240. 4234.
That's not good. So I had to go today and get a provisional license. I have a.
We're looking at page 8 on the transcript you have.
I'm looking for it, yes, sir.
It's that first full paragraph with her, okay? She says she has to go and get a provisional license that day.
Yes.
Correct?
Yes.
And this would appear to be in reference to the ignition interlock license again?
Yes.
And just so the members of the jury understand, we've talked about this a little bit, but if somebody gets a DUI charge and has a suspended license, they can go and get an ignition interlock permit, right?
It's something through the courts, not through the sheriff's office, so.
Yeah, I know you guys don't hand them out, but it's DDS that does it. Does that sound right?
Yes.
Okay. Well, the point is they don't have their original licensing. Sorry.
That was my error. It'll come back on.
All right. I didn't know if we were ending early.
It'll come back on, hopefully.
When you have a provisional license, meaning an ignition interlock license, you're permitted to drive cars only that have interlocks on them.
I'm familiar with what the interlock system is, but I'm also familiar with the provisional license, such as work, school, medical, stuff like that. I'm not familiar with the actual license.
Okay. As you sit here today, do you know whether she had actually gotten an interlock permit that morning or not?
I know there was an interlock in her car.
Okay. Meaning in the Porsche,
That is correct.
not in the Kia, which is
I believe so.
Mr. Barron's car.
I believe, yes.
Okay. Let's go to 4819.
Where?
19.
Did you skip?
4819. 4819. Okay.
42.
I'll roll that back manually. I'm trying to get to 4819 so you don't have to find that. You're 4823. You can see that. You don't need to tell you. From here? You can try from there. We'll see how we do. 4823. It's definitely not in violation of your.
Yeah, and then positive engagement.
4813 on mute, Judge, until 4819 will unmute.
Get me right across here. And then he took that gun. I put it right, he said, I'll shove this down your throat. And he told me to get out of this way. He told me, don't go to sleep. So I said, I'm leaving. But I was scared to leave because I had a couple drinks. You know, been intoxicated, but I had a drink and then I was I had one drink and then I was still drinking a drink when all this happened. So I went and got my gun. And I don't know why I got my gun. I was going up the stairs. He said, I got your phone and your journal. And I was going up the stairs to get them. Is he okay?
I will learn that here in a minute.
All the sounds so stupid.
It's okay.
I was coming back up the stairs because he's never gotten like this. Ever. I mean, he's pushed me a few times, and I don't know what to tell you. Everything.
Well, the more you tell me, it helps me understand what happened.
God, please help. I just need to know how he is.
We'll find out in a minute. So,
She asks you at the front end of this scene we just watched, is he alive? Is he okay? Right?
yes,
She's checking to see if he's still alive. That's her question to you. Right?
yes,
You tell her we'll learn out here in a minute, which obviously you knew he was deceased, but you're keeping that from her. You don't disagree with that.
nope,
And then she says, I don't know if I should tell you everything. And before that, he's pushed me a few times. I don't know if I should tell you everything. And then she says, please, God, please know, I just need to know how he is. Bottom of page 9.
Hey, Justified, I'm sorry to hear you're not doing so great, but we'll give you if you come for a distraction, I'll provide a distraction. I'm going to send you all the good jujus, okay? I hope things get better, babe.
Correct?
yes.
Before she makes a statement,
Holy
is he alive or dead?
guacamole.
Please just
Hold
let
on
me
a
know.
minute.
Please let me know.
Thank you, Nature Rocks. 35 months of membership. Thank you so much. Thank you for supporting me in the channel. I really appreciate that. Thank you. Let me rewind it just a scotch because I don't want you to have missed any of this scintillating testimony or cross-examination. I don't even know what this guy's trying to accomplish here because it ain't looking good. You use the word rehearse. That's problematic.
Page 9. Correct?
Yes.
Before she makes a statement, is he alive or dead? Please just let me know. Please let me know. You tell her you don't know. Then she says, I don't know if I should tell you everything, and asks again, is he alive? And you say again, we'll find out here in a minute. Right?
I agree.
Certainly, you suspected there was something you weren't being told.
Yes, as the interview grew on, there's more and more questions.
Right here, where she says, I mean, he's pushed me a few times. He's never gotten like this ever. I mean, he's pushed me a few times. Pause. I don't know if I should tell you everything. You suspect when she says that, there might be things she's not telling me about the history between these two. Correct?
Well, and that is when I said, well, the more you tell me, it helps me understand what happened.
Sure. And the more you tell her, helps her understand what's actually going on here. Whether he's alive or dead.
Objection argumentative.
Fair enough. Which one? It seems to me, and you disagree with me if I'm wrong, she seemed to want to know if he's alive or not before she's going to tell you about the things that have happened. Do you agree or disagree?
Disagree.
Tell me why you disagree.
Because I think she was cleaning up the scene. She knew that she had made a mistake, and she was trying to figure out. I think she probably knew he was dead because she did make a comment, there's no pulse. But she's just, at this point, trying to figure out the story she's going to stick with, because she started off strong with the stage scene. It was a shootout to, oh, he never shot at me, to where she even cleaned up the evidence and says, through your own state, shot the gun. So she's trying to come up with a story. I think, personally, that at first she thought it'd be easy to conjure up a story. And then when she's sitting in a room with an investigator, it's not so easy to come up with facts and the details, and that's why we're harping on this.
In other words, when she says, he's pushed me a few times, he's never gotten like this ever, I don't know if I should tell you everything, you did not think, hey, there's more to the violence between them in the past. You didn't think that.
Yes, I always think there's more, and I want them to tell me. Like, that's always the goal.
Right. That's the goal, right? You want to know.
Yes.
And she's hinting to you, I don't know if I should tell you everything. Is he alive? Is he alive? Is he alive? Right?
For the picture you're painting, I see where you're going, and I will agree with that, but there's two sides to it, I believe, so yes.
All right. Chris, go ahead and roll it.
Stairs. It was like, I don't know if he shot the gun or if he slammed the door, but something like went flying. I don't know, something was really loud. And then he said he had my journal and my gun, and he locked the door when I got up there. And I told myself, I'm going to shoot the lock off if you don't open the door and give me my gun. I mean, give me my cell phone. And I shot the lock. And he must have been standing right there.
This is the first time. This is the first time where she's actually demonstrating for you how it was that she shot the lock, physically. Did you see it?
Yes, and then with statements made, yes.
Yeah.
Then where she finished with, I heard him.
When it comes into her mind and she's remembering exactly how this went down, you would agree with me, what she's doing is going like this. Did you see that? Did you see that?
Mm-hmm.
You would agree with me, that's exactly how she's describing how the shot's made, right?
In this context, there's, yes.
One of your biggest arguments for how it is that she must have intended to kill him is because that shot's way too high if she's shooting at the lock.
At some point in the interview, she said she was standing close to the door, and that shot was too high, and she also says multiple times that she heard him.
And we'll get to every one of those. Okay. You're saying this shot's way too high if she's shooting at the lock, and she's demonstrating for you, literally, this is how I fired the pistol, right?
I see your demonstration, yes.
Yeah. And if somebody is actually holding a pistol like this, are they going to be accurate with that pistol?
Depending on, that's, in a sake of argument, I'd say they would hit their target, yes.
Okay? That's how you hit a target.
Well, when you're close distance point shooting and you're speculating that, I would say that yes, you still hit a target without looking at the front sight.
Okay. Let's go 5640, Mr. Van Rossum. Stop going, Chris.
He put his gun on my lip and said, I'll shoot your brain out, blow it up his throat. That's when I said, I got a gun too, David. Like, why did I shoot the lock? Why did I shoot the lock off?
So when he stuck his gun in your mouth, you know what I'm
No,
saying?
he stuck it to my lip.
Okay.
No, he put it in my mouth. No, he put it right on my mouth.
She says he put his gun on my lip. It's very specific. Put his gun on my lip and said, I'll shoot your brain out, what's left inside of your brain. You see that? This is page 11, I'm sorry. Page 11.
Yes, this time she does say that there. This
Right.
time.
It's very specific, on my lip, right?
And other times she says, I'll shove it down your throat. Like she bounces back and forth with the same thing.
I'm talking about where the gun is placed on her physical body by Mr. Barron.
According to her statement,
Yes, sir.
yes, that is what she said this time.
Well, and we'll talk about whether she said something different, but he put this gun on my lip. Very specific, right?
Yes.
And then you say, so when he stuck his gun in your mouth on the stairs, and she corrects you immediately, doesn't she?
Yes.
She corrects you, no. He stuck it on my lip, not in my mouth. He put it right on my lip, right?
Yes, that's what.
It may sound like a small point, but she makes that point over and over and over again with you, that the Beretta was on her lip, not in her mouth, doesn't she?
Yes, she said it multiple times.
What was in her mouth if it wasn't the Beretta? If you know.
I do not know.
5843, Mr. Van Rossum?
Why did I touch it? I know better. I wasn't trying to shoot him. I was just blowing the, I was trying to, and I told him, I said, if you don't open the door, I'm going to shoot the lock off, David. Tell me why you walked over there.
The statement she makes is, I don't know why he walked over there. Did you hear that?
Yes.
What's critically important, if we're trying to guess at her intent in shooting through a closed door, is does she know what's on the other side? Does she know where he is? You would agree?
I will also say another point. She said she thought he was on the bed. That is still the same direction of the bed.
Absolutely, I agree with you. She does at some point say she thinks he's over on the bed. I agree with you. Here, well, first, do you agree that determining where she knows where he is on an outside of a closed door where she can't see. You don't disagree she can't see on a closed door.
I do not disagree with that.
We're talking about hearing. We're talking about hearing is her only sense to know where he might be.
Yes, and she stated multiple times she heard.
We're going to talk about those, okay? But the first thing she tells you is, I don't know why he walked over there, meaning to the place where he got shot, right?
Yes.
Walked over there from some other place, right? And the other place that she does mention, and we'll get to in a minute, is on the bed.
Yes.
Okay. You go ahead and, well, let's go to 10204.
If you don't mind, what page?
It is on page 15.
Sorry, Led. Okay. Would you like to take a break now?
Maybe we should. This one. Yeah, this one. Thank you, brother.
We're going to take an early lunch. Let's come back at 12:45. I appreciate all the jurors' attention. I understand we're now into week 2 of your time. I will say that this is a serious case. We have serious lawyers. We need your serious attention. And if you need to drink coffee or Monster or whatever you want to do, I would encourage you to do so. Back at 12:45 for continuation. Thank you.
All right, I just want to say if they got anything they're going to argue about, and then we'll skip the lunch through the lunch.
All right, y'all can be seated. Anything from the state?
No, Your Honor.
Anything from the defense?
That's right.
On defense's objection as it relates to the expert and the medical records, I'm not quite sure, so I'm going to give you kind of a preliminary ruling, and y'all can work around it or let me know if you need clarification. The state's motion is granted to the extent the defense must permit the state to inspect and copy medical records or reports that the defense expert actually relied upon in forming the opinions to be offered at trial. This is obviously consistent with reciprocal discovery, which requires disclosure of the basis for expert opinions, including summaries of underlying reports of examination or test when the defense intends to introduce such evidence. We're not at that point, obviously, but arguably we're getting to that point, so this may be premature and it may be moot. To the extent records involve defendant's own medical information and privileges asserted, the court finds that any privilege has been waived by the defense decision to place the defendant's physical or mental condition at issue through the expert's testimony. Again, I assume that's where you're going on that. However, if the records, this is important, however, if the records are in the third-party materials not in the defendant's possession or control, the state can proceed by subpoena and appropriate notice if appropriate. The court will allow a reasonable time frame if we need to. Not saying the parties have to cooperate, but certainly that would be appreciated to not delay the trial. But if we need to, under reasonable, we can.
Judge, I don't mean to interrupt, but while we've been in court, I had my investigator contact the jail, and he was able to get me all of the defendant's jail intake records.
Okay.
So I have about 800 pages worth of jail intake medical records for the defendant. So
Thank you for that update. All right, so assuming that that's everything, if specifically requested, subject to in-camera review, if y'all can't agree upon something, let me know.
Yes, Your Honor.
And I can do an in-camera review for sensitive portions and go from there. So it sounds like y'all are heading to a meeting of the minds, which is fine with me. We're not quite there yet. If you need further court involvement, let me know.
Yes, Your Honor.
Thank you.
All right, anything else?
Not from the state, Judge.
Yes, sir.
See you in an hour and 5 minutes.
Your Honor.
Testimony, but I do agree that she had one from that testimony.
The 28th, is it?
And
All right, we're back. Anything from the state?
No, Your Honor.
Anything from the defense?
Yes, sir.
Let's bring it back. Thank you.
Okay, so if you guys are wondering what that little back and forth exchange was regarding, what had happened in the morning is the defense intends to have an expert witness testify for the defense. And there was an issue because the defense had not provided the material that the professional, she's a mental health professional. I cannot remember right this second if she is a psychiatrist or a psychologist, but bottom line is they didn't provide the material that she used in making her reports along with her evaluation. They have the evaluation. They just don't have that other material. That's what they were talking about. That's what they were asking. And that's that. Neat says, I think it's possible that he was abusive, but I hope that he has something to back that assertion up if that is what he is going with. I agree. It's going to be very difficult for the jury because let's say that they believe that he is abusive. Now, I need to look into this and I'll do it while the testimony is going on. But I know in Florida, and I only know this because of the other trial, the ballerina trial, where she killed her husband. Sorry, he was her husband. They were married. In Florida, for a stand your ground case, you don't have a duty to retreat. Meaning, if somebody is threatening you physically, like with a weapon, you don't have to try to flee before defending yourself. I don't know if Georgia has that same law. Let's say that they don't, okay? Let's say they do. Either way, it doesn't matter whether they do or whether they don't, because at the end of the day, he did retreat. He went into a room. He locked the door behind him. She could have left. Granted, she wanted her phone. Okay, you don't need the right thing to have done. The correct way to handle that situation would have been for her to leave, go to a neighbor's house, call the cops, and let the cops deal with it. Let the cops get your phone back for you. Not go and confront him with your firearm.
You're correct. You want back on your laptop?
Yes, sir.
Just a little sidebar here. The Nuggie has a Chick-fil-A sandwich that she would like to have for lunch. It's been in the refrigerator because whatever. Anywho, it's in the refrigerator right now. Any tips or tricks on heating that up the best way? Considering that, yes, I have an air fryer, but it is not like one of those counter air fryers. It's part of the Instapot. So you know it's going to take 7 years just to put that thing together so it can be an air fryer. So if you have any tips or tricks on heating a Chick-fil-A sandwich, please put them in the chat. That is all. Let's go.
All right, welcome back. Thank you so much. All right, thank you so much. Please be seated. We have everyone back. Thank you. Again, if anyone needs a break, let me know or let one of the bailiffs know. Any longer-term issues, let us know as well. All right, we're back to cross-examination from the defense. If you would hit the red button on that microphone, turn it to green. Perfect. All yours.
And we're going to go to 106.11. That's on page 17 of your transcript at the top. Okay, go ahead.
Wealthy,
When did you find this out?
because his son told me that he was sending her money 2 years ago.
Okay.
Yeah, and then he found out and he said, this has got to stop. His son did. And I told, one night I called his son because his dad was drunk, drinking, and I took his car keys from him, and he got mad and pushed me. And I was scared. I locked myself in the closet. And he knew, and I took the car keys, so he was like looking everywhere for the car keys, and so he like threw all my stuff everywhere in the closet, and I was just in the corner.
When was this?
Okay. This part of the interview, she's talking about the telephone call from December the 28th, 2024, that she placed to James David Barron's son, Evan, right?
I would agree. It doesn't say his name, but I would agree through the context.
And her statement is, I called his son because his dad was drunk or drinking. I took his car keys from him, and he got mad and pushed me, right?
That's what it says, yes.
Then she says, I was scared. I locked myself in the closet, correct?
Yes, that's what I'm reading.
I took the car keys, so he was looking everywhere for the car keys. And he threw all my stuff everywhere in the closet, and I was just in the corner, right?
Yes.
This version about what happened on 12/28/24 involves her taking the keys to the Kia, to Mr. Barron's Kia, right?
Yes, I mean, it doesn't.
And you know from your other investigation in this case, you spoke to Mr. Barron, you spoke to Evan Barron,
Yes.
right? And you knew that there was a row or an argument or a problem involving a closet, right? Involving Miss Mericle being locked in the closet, right? Yep. Sorry, you have to say yes or no.
I don't remember the lock name, but I do know the argument on the 28th. Yes.
Okay, but she's in the closet,
According to this, yes.
and according to your other information that you
Yes.
have, right?
Are you talking about the interview with Evan?
Yes, sir.
Okay. Whatever his testimony was, yes, I don't
Yeah,
recall.
you were in here. Yeah. She was locked in the closet.
I believe so.
Okay.
I don't, I mean,
And Mr. Barron, James David Barron, is outside the closet, and what he wants is his keys to his Kia.
yes, I believe so.
But where is this spare set of keys that's just freely available to find in the home on 12/28/24? You know?
According to the son, it was in the pantry area by the kitchen.
We'll talk about that in a minute, but I mean on 12/28/24. Where was the spare set, if you know?
I do not know. I mean,
Okay. Chris, if you can go to 1:16:53. 1 hour, 16 minutes, 53 seconds.
with the,
I know not to shoot a gun at a damn door. I know that. I didn't have to do that. I asked him to give me my phone. I asked him to give me my phone. I told him, I said, I'm going to shoot the lock off if you don't give me my phone, David. And that, how am I ever going to live with myself?
So you said you had to go down to get your gun and go back up.
No, I never went up until I had my gun.
Where did you get it from?
My gun?
Yeah, where was it at?
In the master closet.
In the master closet. Is it in a safe or anything there? Just okay.
I just bring it with me when I travel.
Thanks, you guys, for the tips and tricks in the chat. I appreciate that. And I'm sure the Nuggie will thanks you as well, because however I reheat it is going to be delicious. I believe I'm going to use the oven method where you separate all the components. All right.
Can you tell me anything about him, please?
I'll go call it here in just a second.
The police came to my house on St. Thomas.
When was that?
She asks again about his medical status, right?
Yes.
And you say, I'll call here in a second, right? But obviously that's not something you're going to do because you already know, right?
Yes.
And then there's a pause, and then she says, and the police came to my house at St. Simon's, right?
Yes.
Okay, go ahead.
January.
He took me outside.
What is your address down there?
Well, my address is, I use my office address for everything, but
Okay.
my house address is 10 Marina Drive.
And that's where they came to, was 10.
They came to the Seagate Inn.
The Seagate Inn?
It was a hotel. And I was staying there. And they came there. Somebody called the police because they said they could hear him yelling. And the police came, and then he took me outside and asked me what happened. And he said, did he hit you? He said, what are those marks on your face? And he told me, to tell the police and call them to arrest charges. And I said no, and then he left. Then the police left, and then David left.
Did they have him leave? Did the police have him leave, or did he leave on his own?
No, I told the police everything was okay. We told them everything was okay. They came in and talked to us, and then he said he was going to leave, and the police said okay. And the police left, and then David left. And then I called a friend of mine, and then I went to my condo.
And that was January of this year, 2025?
She's relating to you the St. Simon's incident
Yes.
that we know is from January the 28th. Does that sound right?
Approximately.
And her version here to you is the police come there, somebody else called because they could hear yelling. She never mentions anything at all about the softball-sized injury to her head, right?
The one that she got from falling on the ground from the door.
The one that she sustained from David Barron on this incident.
I think that was inaccurate from the testimony, but I do agree that she had one from that testimony, but that's not what we received, so yes.
I just want to be super clear. Does she tell you guys, I got a softball-sized injury on my head from this St. Simon's incident?
Read it one more time. Just make sure I'm not missing anything in these 3 paragraphs.
Okay.
So what I read here is those marks on the face, which I believe the officer testified he was able to identify by rubbing her cheeks. But I don't see anything about a contusion here.
The answer to my question would be no.
Yes, no, correct.
If she's trying to do what you've suggested that she was doing here, which is to stage a scene, make it look like she's defending herself or something like that, why not tell you about this documented injury that she sustained at his hands?
Why not? I mean, I can't answer that question honestly.
You don't have a theory?
You want a theory?
Yes, sir.
Okay, I thought we were talking factually. Again, I think at this point, the stress is through the roof. She just shot somebody. She knows what happened. I can't even imagine to say what was going on in her head, what she's trying to come up with and not come up with. And I don't know why she didn't tell me about this in this part right here. I can't comment on that.
Well, but you've suggested that what she's doing is trying to come up with a version to mislead you and make him be the one who's guilty here.
I think she was coming up with a version to make me understand the scene. That's what I was testifying to. Why nothing's adding up. She started off with, yes, you're right. He was violent. He did all this with a gun. But then we get here, and she never wanted to tell me about the facts of the scene. And that had changed rapidly through the interview.
She's started off with these deputies before she thinks he might be alive. She's telling them all sorts of things, right? Mm-hmm. I was so scared. Prior violence, she actually nods. I thought he was going to kill me.
Look, she's a dentist, but dentists do have, you know, they are a doctor. They do have medical training, for the love of Pete. And she knew that man was dead. Stop playing with these people. Stop it right now. There's no reason for her to have staged the scene at all if everything happened the way she said it happened.
Don't go to sleep. I was going to leave, but I was scared. If I moved on, he would kill me. He would shove that gun down my throat. I wanted to sleep upstairs with the door locked.
Judge, I'm going to object that defense counsel's not actually asking a question. He's just
The question's
reading
coming. Question's coming.
What's your question?
Question is, she's told first responders that. Those statements, yes?
Yes.
Those are statements that someone's afraid. Someone could be afraid because they're being assaulted. You wouldn't disagree with that?
No.
And then she gets in an interview with you. She thinks you would agree that he's still alive. At least that's a possibility.
That's a possibility.
And she's got the opportunity to tell you, hey, I've gotten this giant injury from this man, and she completely leaves it out. Right?
You keep saying she got it from the testimony we heard, that through the door fell back in her head. He did not intentionally give her that from the testimony we heard.
Even under the version the police got. He blasts through the door, knocks her over, and she gets a head injury.
Yes, as he was locked out to get her stuff, yes.
And that's her fault.
I'm not drawing blame here. I'm just getting the facts straight. Yes.
Okay. Well,
I mean, the fact of the matter is, at the end of the day, it's just the end of the day, but the bottom line to all of this is she can say whatever she wants, right? She said she didn't flush any of the bullet casings or any of the live rounds, but she admitted to flushing the live rounds after confronted with the evidence that there was blood, footprints in front of it. And she came up with some contrived story, but she swears she doesn't flush the shell casings, even though that's not true either. I mean, she said a lot of things. And the problem is that when you lie, it doesn't even matter who you're lying to, whether you lie, it doesn't matter. If you lie, you become a liar. And then everything you say after that becomes suspect. Cannot be believed.
all right. Well, why? Why all this to the first responders, and then as soon as she thinks he's alive, why doesn't she tell you about it?
That's what I'd like to know.
12600. Did we just do that? We just did 12600.
Police come to St. Thomas Island because someone called about.
Well, in January is when the police called. And someone called the police. They came to my Seagate place and said someone heard him screaming. And then they left, and then David left. No, just wait a minute. No, yes, that's what happened. Yes, that's what happened. Wait a minute, hold on. That's the night my friend. No. think that was, the police came was in December, as they came, and then my friend, a couple of them, they came over and followed me to my other condo, and I locked the door, because David could get into the Seagate when there was a code.
Another opportunity to talk about the St. Simon's incident at Seagate and to mention the injury, but it's not mentioned here. You would agree?
Yes, you did not mention it here.
128 and 47, 128, 47.
What page?
Oh my God.
Here we go. Okay, let's start this again because I don't know why it booted me off. Hopefully we're not buffering. Looks like we're good. Okay, so Justified says, Jonah's mom, exactly. The only reason for such determination is what's on the phone. All right. But in opening statements, her defense attorney said he had already seen the text on the phone, which is what was the catalyst for all of this. So he already has seen what's on the phone. He's already, according to her, pissed off about what's on the phone. This is why there is something, I don't think the phone was it. I don't think the phone had anything to do with what happened that night. I think he fell asleep in that chair. I think she was into the cups. I think she's an emotional drinker. And I think as she was sitting there watching whatever the hell they were watching on the TV, I think she started thinking about Lilia. I do. I think she was hurt. I think she was angry. And I think that she can confront. I think she did try to wake him up to go to bed, right? But I don't think it was to go to bed. I think that might have been the excuse that she said to him, oh, come on, let's wake up. It's 11 o'clock. Let's go to bed, right? But I think actually what she wanted, because then she tells us that they were getting ready for bed, brushing their teeth, right? And she starts in on the Liliana thing. I think the bottom line is that what she really wanted was to confront him and argue with him about Lilia. And I think for his part, I think he strikes me as the type of person, due to his texting responses, that it's not that he's avoids confrontation. To me, the way that those texts read to me is indicative of a person who When they see that a conversation is going in circles and nothing is being accomplished, it ceases to become productive, the conversation ceases. I think the phone was an excuse. There is something in my gut that is telling me that phone, I'm not even sure that phone was in that room. She also says during the interrogation that she doesn't care if he has her phone or her journal, which wasn't even up there either. See, that's where I'm stuck at with the phone. Like, if a person will lie about one thing, they'll lie about anything, right? So she's lying about what he took with him up those stairs. The lie being the journal. The journal was not up there. It was downstairs in the bedroom, master bedroom. So she'll lie about the journal being up there, then she would lie about the phone being up there. That's why I don't believe that the phone was up there.
It's page 30, top of the page.
Oh, I can get behind that justified.
That's good.
That she's
153.40.
hold on. That she's going to decide when the fight is over and you do not turn your back on that person. Yeah, I can get behind that. Absolutely. Oh, here we go.
Oh my God. Oh God.
159.27. $159.29, Judge. Page 31.
But when he threatened me, he didn't put it, he just touched it to my lips. He didn't put it in my mouth. And then he went up the stairs. And I said, I have a gun too. Because he said, don't go to sleep tonight.
Yeah.
And then I went and got my gun. Okay? He was upstairs. Then I noticed that he had my phone. So I went up the stairs and I said, when I went up to the stairs, I got right to the first floor, and then I heard, and it sounded loud. And I don't know if it was a shot or he slammed the door, but when I got up there, the door was locked. And he was in, and I said, do you have my phone? He said, yes. And I said, you open the door. Now, and I was banging on the door. And he did open it, and I said, I'm going to shoot the lock if you don't open it. And that's when I put my gun right in the corner of the door, like where the lock is right there. I think I put it a little bit. And I either put it up and shot, or I know I shot one down because I saw it and it scared me when I did it.
At this point in the interview, she talks to you specifically in that, probably about fourth paragraph down, about an interaction, what seems like at the door, right? She's saying, do you have my phone? Middle of that larger paragraph. And he said yes.
That is correct. You heard him say yes.
And I said, you open the door now, right?
That is her statement.
And I was banging on the door.
Yes, correct.
And he didn't open it. Correct?
We agree on that.
And I said, I'm going to shoot the lock if you don't open it.
Yes.
Will you agree with me that in all of these hours of questions that you had for her, you never asked her a single question about where David Barron was in the room when he responded to her and said, yes, I have your phone?
Well, it's pretty obvious.
How is that obvious?
Well, she heard him. She struck him, so we know exactly where in the room he was at the time.
Will you agree with me, you asked her zero questions about where he was in the room when he responded to her? Yes.
I'll agree with that because I knew where he was.
Because you knew where he was.
And she did too when he said yes.
In other words, when someone says something on the other side of a closed door, the person on the outside of the closed door knows exactly where they are in the room.
If you say something, yes, you can get a direction from sound where people are.
Wouldn't it be helpful to say, Ms. Mericle, when he said yes, where did you hear him in the room?
Hindsight is 20/20, and I do agree.
We know, and she says this at some point, I thought he was on the bed.
That is correct.
Why does she not think he's on the bed when he says yes?
Well, in all fairness, where he was standing and where the bed is a straight line. Like where he would be laying in bed versus where he was standing is still very correlationally appropriate.
Meaning, even if he's in the bed, the shot that she took would have got him on the bed.
No, I'm not saying that. I'm saying that it's still the same direction.
Okay. Well, let's just see. Okay.
Is there a crime scene photo from the door that is a little more representational?
Yeah. Why don't you come and help me find it amongst these hundreds of pages, if you can. No, they're clearly not any
Right here. Right here. This is, there's the thing right there. First one, the bed is still in the same direction. That's where he was with the door.
Let's come on down. We're looking at State's Exhibit 45, okay? Can I have a witness step down there? Demonstrate on State's Exhibit.
If you don't mind, use a Elmo at least preliminarily. Y'all can, I'm not telling you how to try the case, but I can't see what y'all are looking at.
Can I do it if we switch off the camera? Will it?
Yeah.
Can we lose it?
Well, no guarantees on that, but.
Okay, fair enough. Okay.
All right, and again, you might want to adjust the neck a little bit of it. There you go.
Is that better? There's a little bit of glare there, obviously, but I'm going to do this.
All right, and then if you don't mind, use whatever screen y'all want.
Well, first of all, the shot comes through right through here, so we think he's here, right? When the shot happens.
Yeah.
Yeah. And she's right outside there.
Mm-hmm.
If she thinks he's on the bed, that's not in the same direction.
It is. It's, excuse me, not being argumentative. I'm just, the bed is over here. If you look at the layout, yes, that's, when I was the crime scene, that's one thing I was looking at. It still goes back towards the bed.
Okay. Where did we leave off? 2 and 53? Judge, can we switch back? I'm sorry. All right, let's go to 2:18:57. And that would be page 40 for you.
I think it's found, yes.
Come back some as opposed to. That's 2:8:52, that's fine. 2:18:52, Judge.
I don't know why I got it. I mean, and then when I went up there and the door was locked, I was like, David, open the door. Give me my phone back. I banged on the door, banged on the door, banged on it. And he went open it. He said, I have your book too, or journal, or whatever. And I said, David, give me my stuff. I said, okay, I thought he was going to open the door, but there was no screaming, nothing. And I said, David, I'm going to blow the bolt off or the gun or shoot the lock off. And I shot. I just think I shot it one time.
He or she's describing banging on the door, banging on the door, banging on the door, and he wouldn't open it, right?
That's correct.
I have your book or journal too or whatever. David, give me my stuff. I thought he was going to open the door, she said, right? Mm-hmm. Then she says, there was no screaming, nothing. And I said, David, I'm going to blow the bolt or shoot the lock off, and then I just shot, right?
That's correct.
This still doesn't help us to understand where he was in the room from her perspective. You would agree?
With the earlier statement of her saying yes, and then now, when you add this statement to it, we also have him saying, now we've added to this that I have your, let me find the exact quote.
Your phone in your journal.
Yes, now you have your phone in your journal, which also adds to the yes, which gives more dialogue and more voice behind the door for locational purposes, I believe.
You don't think this is just a further explanation of the one statement that he made to her? I've got your phone or journal or yes?
No, because I think when she was threatening to blow the lock off the door is when he moved to the side of the door. You know, he knew if she shut that door, he did not want to be in front of it. So it was just a voice.
Hang on. If he thinks that she's going to shoot the lock, this is one.
Hypothetically, that's what really happened when we're in there.
If he thinks she's going to shoot that door, if he thinks she's going to shoot the lock off, why would he go right in line to the lock?
Speculation.
He didn't. He stepped aside.
Objection calls for speculation.
I'm not commenting on the evidence. The jury will make the determination. I will allow the questioning to continue overruled.
He didn't stand in right line with it. He stepped to a side from what he thought in line was.
This is the wall outside of the room right here, okay? Mm-hmm. And the door is right here in front of me, right? And she's saying, I'm going to shoot the lock off. Mm-hmm. And he goes and stands exactly right where the shot goes through the lock.
It's unfortunate. And that's why I think she heard his voice. Because most people would intentionally think you're going to shoot straight in, not an angle through another wall for somebody to take offensive position.
If she's announcing, I'm about to shoot, wouldn't you think you go further back into the room or the closet? There's a closet there, right? There's a closet there.
Coming around, yes. Yeah. But I can't speak to that. I just know that he was standing off to the side. He was not standing directly in front of the door.
Page 44, if you wouldn't mind. 226.55, Chris. And you can go a little bit beyond 226.55 to get close. That's probably fine.
No shell casings.
So where were the other holes?
In the glass?
In the bedroom?
No. In the window.
Well, I only shot to the door.
You only shot to the door?
With my gun.
And he never shot, you just started slamming the door?
You know, my ear?
Yeah. But you did hear a couple of gunshots. You just heard one loud bang.
I heard a loud bang.
We know for a fact that one shot went through the door, striking Mr. Barron. True?
Yes.
We have ideas about how many shots came out of the bedroom afterward.
Yes.
Cameron Durham says 3 is his guess.
Yes.
Right? Could be 2. But 3, 2, 3, 2, right? One of those.
Yes.
And again, your words. If she's trying to stage the scene and tell you a story, why would she say that he only fired one shot?
Because at that time she knew that she could no longer hold the story. She was in an interview room in stress. She couldn't make the fine details work.
Well, she certainly would know how many times she fired his gun if she's the only one who fired it, right?
At the same time, she's also telling me how she didn't flush shell casings.
We'll talk about that in a second. But she knows how many shots are fired.
If the interview at this point I believe was truthful, we could have this conversation, but I can tell you what she said.
My question is, why doesn't she tell you there's more than one shot that he fired at me?
Judge, there's so many speculative questions here that this witness cannot testify as to why the defendant did or didn't say something, what she was thinking, why she was thinking it. These are all speculative questions.
Y'all come on up.
23804, Ms. Reynolds.
How could he possibly answer that question? That was a good objection. It was all speculative. He cannot know why either person did what they did or why she said what she said in the interview room. Okay? Come on.
He's got a really big heart.
Sounds like he's a great guy. Sounds like he's a great guy from good to done.
But why did I do that? How am I going to tell my children? How am I going to tell his children? I shot him. God, please let him. God, please take care of him. Why did I do that? I was going to leave, but I was scared to leave.
Here, you've left the interview room, and only Detective Cuneo is in there with Miss Mericle.
That is correct.
And what we get is another statement about being scared to leave, correct?
Yes. The context, though, follows up with, because of last time, there's no way I was intoxicated.
Going back to the ability to leave while being under the influence or while consuming alcohol.
Yes.
23928. Oh, boy.
50.
Hang on one second. Oh, my gosh. 23928.
On the phone at the door and you were.
No, we didn't go back and forth.
Okay.
No, we didn't. I said, do you have my phone in there or whatever? And he said, yeah. I said, give my phone. That's it. I said, I'm going to shoot the lock off if you don't give me my phone now. Nothing. And so I shot it.
Investigator Cuneo says to Miss Mericle, you said y'all were going back and forth about the phone at the door. You see that?
Yes.
And Miss Mericle responds, no, we didn't go back and forth. Right?
Correct.
And then she says, nope, we didn't. This is Miss Mericle. Nope, we didn't. I said, do you have my phone in there or whatever? And he said, yeah.
That is correct
Right.
to see where she was able to hear him say yes.
We've been over that, that's for sure. Right?
Yes.
She heard him say yes, right?
Yes.
The question is, where is he in the room when he says yes? Right? Right?
That is your question, yes.
And then she says, I'm going to shoot the lock off if you don't give me my phone now. Nothing. And I shot it. Correct?
Correct.
24112, Ms. Van Rossum.
I mean, 3 hours ago we were together. I'm such. I don't even know. I don't even know what to say. I know better. I'm sick. So what? Why did I take my gun up there? I really thought he was going to be on the staircase waiting for me with his gun. We were going to shoot each other. I mean, God, I wish I could go back. I would have never. I wasn't planning on doing anything. And he was right there with it. I'm just saying, I don't think, if you ask me if I shoot the door, I'll tell you no. If you ask me, I think he'd shoot me and say no. But when he put the gun like that and said that to me, he's never done that. And when he hit me in the head, he's never done that.
Here, Miss Mericle is stating that he has never pointed a gun at her. I think she says like that, right?
That's correct. That's what I'm reading.
And when he hit me in the head, he's never done that.
That is what it says.
24651, and be careful about your start time here.
What page, sir?
Page 52. 4651. That's better than 246, that being earlier, yeah.
But he wouldn't get out. And I never thought he would do that.
Can you roll it back and go to 246? 24651.
And you say that's, what
It's on
page?
page 52,
Oh,
middle of the page.
Okay,
May I approach witness? I'm just going to indicate some of the transcript.
I was on 51. Yes, sir.
We're not talking about that. So
That's fine.
cross that out.
Okay.
Yeah, it starts with there.
Okay.
Okay.
Yes.
24651.
Then he wouldn't let me get out. And I never thought he would do that. I can't believe I shot through the door. And hit him. So stupid. Stupid. I didn't know. Maybe somebody thought he was laying in bed.
You hear that one? I thought he was laying in bed.
Yes.
Two 4900.
God, I should just got in my car. I told him, I said, I'm just gonna go. I'll just go and get a hotel room, okay? And he said, you better not go. You won't be able to get your car started. I said, well, can I take your car? He said, no. But I know that part. And there's no lock on my bedroom door.
I should have just got in my car. I told him, I said, I'm just going to go. I'll just go and get a hotel room, okay?
Yes, that is what's said there.
And then Ms. Mericle says, and he said, you better not go. You won't be able to get your car started. Correct?
That is correct.
I said, well, can I take your car? And he said, no.
That is correct.
And she says, I forgot about that part. And then the next line is, and there's no lock on my bedroom door. Correct?
That is what's said here. I mean, there's,
And this is sort of similar to what she was saying earlier about there being no lock on the door downstairs, but the lock's upstairs.
there's other bedrooms in the house, yes, that do have locks,
Right, one of them is upstairs,
and one of them's downstairs. yes.
in the basement.
Yes.
Which we haven't seen
Okay,
any,
yes.
I don't think pictures or photos or videos yet of that.
Okay.
Further downstairs, would you agree
Yes.
with that?
Yes.
Looking at 3 hours, 3 minutes, 13, so 3:03, 13.
60?
Page 60, exactly.
Not doing anything with the door open, right?
Oh, yeah, when I
So-
pushed the door open, he was there.
And all you heard was loud bang, not multiple loud bangs going on.
The only thing that could happen is he had his gun.
Mhm.
He had his gun with him, so if he shot his gun, he shot that. Before, when I was walking up the step, I heard a loud bang. I think it was the door, but he's the only person that would have his gun.
But it was only one, wasn't several
So for what?
loud bangs? Just one?
I just heard one.
Okay. So,
Another opportunity to say multiple shots, and she goes with one.
correct.
And also, it could have been the door.
Yes, we were leaning towards the door, I think, for the most part. She was.
3:04:04.
I just brought, I guess so he'd see it. So I was thinking when I came back up that he was going to be there. I don't know what I was thinking. I was just thinking when I came back up those stairs that he was going to be there, but I didn't bring it like to hurt somebody. I didn't. And then when the door was locked, and he didn't say, I thought he was laying in bed.
Another statement about thinking he was in the bed. Correct?
That's what I heard. I can't find the spot in the transcript.
I'm sorry, I should have directed you to it. It's my fault. Page 61.
Okay.
It's the second large paragraph.
Yes, okay. But that is what I heard.
Miss Ellie? Okay. Let me show you what I'm marking as 9, 10, 11, and 12. 9, 10, 11, and 12. Take a look at those.
Okay.
So you recognize those as your crime scene photos?
Yes, this is going to be from the living room looking at the kitchen.
That's defendant's
Table
9.
with the power tools.
That's number 10.
Yes, and yes, I recognize them, but yes.
And 11, you recognize 11 and 12?
Yes.
They fairly and accurately represent the crime scene.
Yes.
Moving to tender 9, 10, 11, and 12.
No objection, Your Honor.
Admitted.
May I have the Elmo again, Judge? 9 is, orient folks, right on top of this chair over here on the left-hand side, you see where I'm indicating here? There was a bullet fragment on top of the back of that chair that was found, right?
I believe so.
This is the dining room table here that we see. There's the kitchen island.
Yes.
Behind that is the range and the backsplash and stuff like that.
Yes.
Looking at defendant's 11, this is sort of a closer up view of that area, of the island area,
Yes.
right? And 10 is sort of the other side of the island. I'll show it to you. Right? And to be clear, a spare set of keys is not visible in defendants 10, 11, or 12. You would agree?
I would agree, but I do think their testimony, and I did not see them, so this is not mine, but would be the pantry.
That's right. That's why we're going to defendants 12. You ready?
Yes.
Defendants 12 is that pantry area, right?
Yes, if you go through that little arch, it hooks back to the right, and there's a little table there. Yes, the door's kind of blocking one of the tables right now, and that's the door to the garage.
You would agree with me, we've got no pictures of that pantry area taken by crime scene, at least, that you're aware of. And
If there's not, yeah. Unfortunate if there is not. It's very unfortunate.
Do we know whether any of the deputies who had body camera running and who came into this house might have walked right into that pantry area and been able to see what was out on the counter, whether there was a spare set of keys or anything like that?
I do not know, but like I said, I think this is more something for the person who actually found the keys.
Sure, and my question is just whether the keys are open and obvious, laying out where anybody would see them immediately, right?
I understand your question, yes.
Have you reviewed, you know Officer Ingalls?
I know him, Sergeant Ingalls, and no, I have not reviewed his body camera.
Okay. Who's that? Deputy Feraldo, Michael Feraldo?
I know Lieutenant Feraldo.
Sorry, Lieutenant.
And I have not looked at his body camera either.
Okay. Okay. But to be clear, those body cameras are in your stuff, in your case.
That should be, yes. I usually go for deputies. We can ask them. I mean, they're uploaded to the same system, evidence.com, yes.
Yep, okay. All right. I want to talk to you now about the texts on the phones, meaning the texts on Ms. Mericle's phone that you've reviewed and testified about here today. Okay?
Yes, we're doing this.
Yeah, I mean, and just to remind everybody, what you did in part was you got Mr. Barron's phone and also Ms. Mericle's phone, and you gave it to the, I think it was London, investigator.
So that process, Sergeant Durham collecting his evidence, then during the process and putting in proper evidence, I prepare a search warrant, and I give him a search warrant, and he retrieves it for proper evidence. So just to be clear.
Just kidding. This is I'm showing you States 186 that was previously admitted.
Yes.
And this would be Ms. Barron's,
It's clear, so.
Mr. Barron's cell phone.
Yes.
And they've called it a clear case. I want to open this up. Do you have I'll rip it if you don't have it.
I do not have an iPhone, but you may want to.
All right, let's take a break. Back in 15 minutes.
Why don't you grab that stuff?
Okay, before we continue, I just want to say something about the keys. First of all, ideally, right, you have a key rack because why? That's where you put your keys, right? All your keys, your spare keys, your main keys, right? They were there that weekend, unpacking, putting things together, all the things, right? So I'm not super persuaded that she didn't know that he kept his spare keys there. Regardless, even if in the moment she didn't know about the keys, she had her feet. She could have walked.
All right, welcome back. Thank you. All right, welcome back. Thank you. All right, thank you so much. Please be seated. Thank you.
I'm anxious to get this day over, quite honestly, because day 5 is where we really want to be.
Make that button green. Yep, we're ready.
May I first witness ready?
Free reign.
You can hand me this.
Well, I'm gonna go ahead and just take out State's Exhibit 186, which is the,
Just a sidebar, free reign. Like Henlou has free reign over everything in Chicken Ladyland.
iPhone that belongs to Mr. Barron, okay? It's got a clear case on it. That's a word, whatever word we want to call for that, light brown, clear, something like that. Fair?
Yes.
And the reason I want to take this case off is because I want to talk about the actual color of the phone, okay?
Okay.
I'm just going to pop it off. So I can make it good.
You want a glove on the other hand? That's got blood all over.
This is the real word. Do you know what the actual color of this phone is?
I do not. I think I was told it was black at one time. I think it looks.
It's gray.
This is my first time actually handling it. I'll look
Okay.
at it.
If you can pull off, getting the case off, then great. If you can't,
I.
okay.
Yeah.
Did you know that Miss Mericle's phone, which is 182, is a iPhone with a blue case on it?
Yes.
We can pop off her case and see that it's a blue phone. Would you agree with that?
Yes.
Blue, and maybe you take my word for it that Mr. Barron's phone is gray.
Yes. It appeared that way through the case. Show me what's marked as defendants exhibits 13, 14, and 15. Let's take a look at those. Yes.
You don't need gloves for that.
Well, you're just taking a bloody phone. Yes. You want to hang on to these for a minute?
Yeah, just take a look at those and see if you recognize those.
I recognize these two. I do not recognize this one.
Okay, tell me which two you do recognize.
The text conversation between Ms. Mericle and David Barron, and the text conversation between Ms. Mericle and a gentleman named Charlie English.
Got it. And that's exhibit 14 is the text conversation between Miss Mericle and Charlie English.
Yes.
Defendant's exhibit 15 is a text conversation between Miss Mericle and Mr. Barron, right?
Yes.
And that one starts on March the 3rd of 2025 and runs all the way up to March the 7th at 11 p.m.
That is correct.
Move to tender defendant's exhibit 15. That's the text between 3/3/25 and 3/7/25.
No objection, Your Honor.
14 you recognize as the text between Mr. Charlie English starting March 5th, 2025
Yes.
and ending March the 8th of 2025.
Yes.
Move to tender defendant's exhibit 14.
No objection.
Submitted.
Defendant's exhibit 13.
Yeah.
You don't recognize these?
I do not recognize the phone number off the top of my head.
Okay. Well, let's see if we can figure it out. 912-230-4039. Recognize that number?
Was that the 4309?
Should be Mr. Barron's phone as well.
Oh, okay. Yeah, no, 4309 was Susan's.
Don't recognize that number?
Not off the top of my head. She had it, Mr. Barron, I do know that the 4309, because that is the phone number she gave me. But hold on, let me look at some notes. I did have Mr. Barron's
Listen, hopefully that ain't somebody else's phone number
phone number.
anymore.
But no, I mean,
Okay.
if you tell me it's it, I'll go ahead and read it.
We'll leave 13 alone since you don't recognize it. One of the questions, obviously, that you had was motive. True?
Always, yes.
Always. What motive was a question that you had and that you wanted to investigate?
Well, facts and circumstances, up and foremost, facts and circumstances, and motive is always good.
And am I correct that your investigation, you believe the motive was that Miss Mericle was angry about the relationship with Lilia Bocan, right?
We have historical amount of text messages to show that, yes.
We have loads of messages about her being upset about that.
Yes,
Other people have heard her talking about it as well, right?
yes.
That goes back to, my gosh, December the 28th of 2024, we think is when she found out?
That is the first documented incident we have, I believe. But did you say November, December at one point, maybe? I'd have to look at the messages to confirm. But yes, I agree with you.
The gist is, we've got something that happened literally months before the shooting.
Yes,
Am I correct if I state that you don't have any information at all about a new motive, a new thing that happened on March the 7th related to Lilia Bocan?
not in relation to Lilia, if you're narrowing it. I
Right.
don't,
And we're going to talk about what might be new, okay? What might be new on March 7th?
are you talking about the ongoing graphic nature with Mr. English?
Yes, sir. So I want to talk to you about Defendant's Exhibit 14, okay? We have elementary.
Okay, so I just heard him say ongoing graphic nature text with Mr. English, okay? I don't know if the defense is going to put those up. I would imagine if they're going to talk about it, they're probably going to have to read them out, so brace yourselves. Also, I don't really appreciate the defense attorney trying to handle those phones without gloves on, for particularly Mr. Barron's phone that was covered in blood. That seems wrong on many levels, but they don't ask me these things in the courtroom. They don't call me. I don't have a direct line. Here we go.
There were messages between Miss Mericle and a person named Charlie English on Miss Mericle's phone.
That is correct.
Those are on Defendant's Exhibit 14, in part, right?
Yes,
You would agree with me that all of those messages, except for one or two, had been deleted off of the phone of Miss Mericle, correct?
yes.
I'll show you Defendant's 14. This is from March 5th, from Mr. English to Miss Mericle. And he states, "It was nice, I'd love to do it again, and I'd also love to see you." Correct?
That is correct.
And Miss Mericle responds, "I'm seeing my boyfriend this weekend, so we can discuss where we are. So of course, we need to wait, because we would be dangerous alone." Correct?
Correct.
March the 6th at 7:30 p.m., Mr. English says, "Hey, it's going great. I'm about to finish up and then go to dinner with some friends here. Did you get to the lake safe?" That would be the evening of March the 6th, 2025, correct?
That is correct.
And you know from your investigation that Miss Mericle drove from St. Simon's Island, arriving in the evening of March the 6th of 2025. Is that right? That'll be Thursday.
Yes, yes. I knew she was Thursday, so yes.
Thursday. And then Miss Mericle responds, "Sounds fun. I'm still in the car. I have 2 hours." And this is at 7:55 p.m. on March the 6th, right?
Yes, it was.
Is that correct?
Yes, there's also a red one that says 8:03, but yes, I agree with the time frame, yes.
Then Mr. English responds, "Ugh, you and always come to my house for a sleepover, March 6th, 8:04 p.m. Right?
It's no text on, yes.
Miss Mericle responds, "I'm sure we would have fun. This is March 6th at 8:09 p.m.
Yes,
And what we're noticing, we already talked about this before, but I want to make sure that everybody sees it. All of these messages that are coming and being shared all have user deleted, right? And the deletion time and date on it. You see that? They're coming in and being deleted by the user, which would be Ms. Mericle. Right? As far as you know.
Correct.
Ms. Mericle responds, 8:10 p.m. My ex and I are going to meet tomorrow to discuss us, so it was probably not a good idea. Correct?
Correct.
Also deleted, not present, deleted text, correct? And I'll shift back to you if you need to see it again.
Oh, no, you're good. Yes, I'm agreeing. Yes.
March 6th, 8:14 p.m. Mr. English to Ms. Mericle, I respect whatever decision you make. 8:14 p.m. March 6th, also deleted by Ms. Mericle.
Correct.
March 6th, 8:15, Ms. Mericle reacts to, I respect whatever decision you make, which was what his last text was, right?
Yes.
It was also deleted.
Yes.
Okay. Then we have a new message, 16 or 18? 8:16 p.m.
Oh.
By Ms. Mericle to Ms. English, sorry, Mr. English. I appreciate you saying that. I know you have women fall all over you. And then response by Mr. English at 8:28 p.m. on March the 6th, but I've always been intrigued and wanted you. Correct?
Correct.
Ms. Miracle's response, March 6th, 9:08 p.m. I'm very strong-headed and sassy. Also deleted by Ms. Mericle, correct?
Correct.
He says, Mr. English responds, love and love on March 6th at 9:08 p.m. Correct?
Correct.
Also deleted by Ms. Mericle. 9:11 p.m. Ms. Mericle says, haha, also deleted by Ms. Mericle. This is still on March 6th.
Yes.
We're getting to the evening hours, really. 9:11 p.m. March the 6th, which is the Thursday.
Yes.
Mr. English to Ms. Mericle, 9:45 p.m. You don't scare me. And Ms. Mericle has also deleted this message as well.
That is correct.
Another message from Mr. English, 9:50 p.m. Heading home from the road back to Athens, also deleted by Ms. Mericle. Right?
Correct.
I'm home. What are you wearing? Sent by Mr. English, 10:22 p.m. Deleted by Ms. Mericle. Right?
Correct.
And then Ms. Mericle, March 6th, 10:39 p.m. I do not want you to be afraid of me. Also deleted by Ms. Mericle, March 6th.
Correct.
Ms. Mericle, let's see the screen here. I stopped and had dinner. I'm headed to the lake house to meet my boyfriend. I have on a pair of running shorts and a jacket. This is 10:39 p.m. March 6th. Correct?
Correct.
Also deleted by Ms. Mericle. Correct?
Yes, correct.
And then we have a message, March 6th at 10:40 p.m. Meeting your sassiness and being strong-headed doesn't scare me. Also deleted by Ms. Mericle.
Yes.
Hey, Jean, welcome in. Glad to have you.
March 7th, 9:25 p.m. We jumped forward a little bit. Okay? We're on March the 7th. This is the day in the evening, I guess the evening hours before the shooting.
Yes.
Looking at this March 7th message, Ms. Mericle says, you went to the store for a minute, correct?
Correct.
Deleted by Ms. Mericle, 9:25 p.m., correct?
Correct.
Mr. English writes back, I will leave you alone. This is March 7th, 9:25 p.m., correct?
Correct.
Also deleted by Ms. Mericle, correct?
Yes.
Then, 9:25 p.m., March the 7th, Ms. Mericle writes to Mr. English, he wants us to get back together, correct?
Correct.
Deleted by Ms. Mericle, correct?
Correct.
Right at 9:25 p.m.
Sir, are you suggesting that there was no, I mean, she was upset about Lilia, but it was no big deal because she had Mr. Mann on the side? I mean, is that what you're trying to say? That this makes no sense. This doesn't, you better like tighten it up, buddy, because this does not look good for your client. Okay. Not really. I mean, it doesn't help her character, which obviously is not what you would judge unless and until she takes the stand, right? But it's at the end of the day, really, I shouldn't say that. the bottom line here is, okay, she's carrying on a side flirt with this guy while simultaneously berating and being angry and incensed and 11 billion other adjectives that I can't think of right now, indignant, and basically on a moral high horse. How dare you? You're sending money to this lady. You don't love me. You don't pick me, blah, 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 blah. But yet she's got Sancho on the side. Okay. It's not helping your client.
After he wants us to get back together at 9:25 PM, March 7th. The response by Mr. English at 9:25 PM is, "I'm sure," correct?
Correct.
Also deleted by Ms. Mericle at that same time, correct?
Yes.
Then Ms. Mericle responds, "Why?" Answering this question, "I'm sure he does want us to get back together." She says, "Why?" Question mark.
Yes, on March 7th at 9:28, yes.
And deletes the message.
Yes.
And then Mr. English says, "I'm sure he wants to keep you. You're an amazing woman." That's 9:29 PM.
Correct.
Also deleted by Ms. Mericle.
Correct.
And then March 7th at 9:31 PM, "Not that amazing. I'm tough to deal with sometimes," by Ms. Mericle. Correct?
Correct. And
Also deleted by Ms. Mericle.
yes.
Yeah, wait till
And
she
then
starts.
Mr. English says,
Hold on a
response,
minute.
quote, "As
Wait till she's into the cups and she has the mads and the sads and she decides to text you. Yeah, that is hard to deal with.
we all are at 9:32 PM."
Also deleted, yes.
9:40 PM, Mr. English sends this message, "Sleep good, baby, I'm exhausted." And then Ms. Mericle has that deleted as well.
Correct.
She replies at 9:44 PM, "You too, sleep well," and then deletes the message.
Correct.
Now, at 9:44 PM, Mr. English reacts to the "you too, sleep well," meaning that he has, given a thumbs up or a like or a heart or something. He's reacted to that text, right?
That is correct.
In other words, he didn't write another text back. He just reacted to it with some sort of approval, right?
Correct.
And this is at 9:44 PM. This message is not deleted, correct?
No, status is red.
Shows it's been read. It shows that it's been read, and that just means that the person that has the phone has presumably looked at this message, this reaction. Someone has looked at it, right?
Correct.
March 7th, 9:46 PM, Ms. Mericle sends this message: "What would you do to me if I was next to you?" to Mr. English, correct?
Correct.
This message is also not deleted, correct?
Correct. Doesn't it?
Now, the next message from Mr. English comes after everything's already happened and it's the next day, right?
That is correct.
The only two messages, and here's what he said: "Good morning, beautiful. My list of things that I would do to you is very long and growing." 8:58 AM on March the 8th, okay? This is the next day. Mr. Barron has already, unfortunately, died at this point. Ms. Mericle's in custody, correct?
That is correct.
The only two messages visible on Ms. Mericle's phone between Mr. English and Ms. Mericle would have been this reacted note, right?
Yes.
And this message here, right?
That is correct.
We know that Ms. Mericle told the first deputies that she told Mr. Barron that she was ending the relationship or moving on or something to that nature. Correct?
Hold on, I'm going to the transcript. Which body camera are you?
I'm sorry? Yeah, that'd be Thomas. And you remember, it's on my flip chart as one of the things that they
Yeah, I'm
said.
just confirming, yes. I don't, it wasn't said to me, so.
I understand, but we know she said
Yes.
to them.
Yes, I'm just confirming because like I said, it was not said to me.
We know that Ms. Mericle said that Mr. Barron was very upset with her about ending the relationship, or words to that effect, to those first deputies. I know she didn't say it to you. Correct?
Yes, that's,
We know that these two texts are on her phone, and we know, do we not, that this would be new information to Mr. Barron.
yes,
According to Ms. Mericle, this very much upset Mr. Barron that she might be moving on, having another relationship. At least that's what she said to the first deputies. correct?
Yes.
What is new with respect to Miss Mericle's motive, as far as you know? What is new with respect to Miss Mericle's motive? Not Mr. Barron's, but Miss Mericle's motive on March the 7th or March the 8th? Motive.
Yes, I'm trying to debate something.
My question is very specific.
Yes.
What's new?
So in this point, yes, we do have her drinking alcohol, and then we do have her with the Charlie English text. Those are the two deciding factors, yes.
That's what's new, is the Charlie English stuff.
Yes,
But that's not new to Miss Mericle. That's only new to Mr. Barron, right?
allegedly.
Allegedly. It's not going to enrage or unhinge Miss Mericle to find the text that she knows she's got. Right?
Yes, but also keep in mind, we cannot confirm that he didn't know, but I would assume and make the assumption with you that he didn't. But
You did, just not 13.
Just not 13. Okay.
I put down that you have 14 and 15.
Yeah, 14.
Yeah.
Not 13.
14, 15, and not 13?
Not
Yes.
13.
15's been admitted, though.
Yes,
Okay.
14, 15.
Let me show you some of the material from Defendant 15. Yeah. Defendants 15, these are the texts between, again, Mr. Barron and Miss Mericle from March the 3rd all the way up until March the 7th, the night of the shooting, okay? Now, you remember some of the evidence. You've been in the courtroom throughout the whole trial because you've been permitted to stay in.
Correct.
There was some evidence that we heard about the Bluetooth connecting to different cars. You remember that?
correct.
Okay. So I want to ask you specifically about this very final week, the March the 3rd all the way up to the March the 7th, that kind of 4-day window. Okay?
Correct.
We know that on March I think it was the 6th or 7th, maybe it was even the 7th, Miss Mericle says, we went and got the provisional license for my, because of the DUI arrest. On
Yes,
March the 6th or 7th, I think it was, right? On March the 5th, March the 3rd, it's a message from Mr. Barron to Miss Mericle asking, hope you arrived safely. This is 3:51 p.m. Do you know where it is Miss Mericle is being well-wished about arrival? Do you know where it is she's going March the 3rd or arriving to?
Would that be the Sunday, Monday, so she could go back to St. Simon's?
Yeah, so March 3rd, she heads back to St. Simon's. She's there Monday, Tuesday.
Yes.
Right? Comes back on Thursday.
Yes.
And Miss Mericle's mode of transportation, March 3rd, 4th, is, as far as you know, don't guess if you don't know, as far as you know, is the Kia.
Correct.
Meaning Mr. Barron's Kia is the way she's getting from Gainesville to St. Simon's, 5.5, 6 hours away.
Yes.
And this is presumably related to her travels on that March 3rd. She says she's getting on the causeway. The causeway, yeah. When you go to St. Simon's, you have to take the causeway to get over down there. Do you know anything about that down there?
In years.
Looking at March 3rd, 2025, 3:51 p.m., Mr. Barron to Miss Mericle, the car is running fine. He's reporting back, presumably about her vehicle, as far as we know.
Correct, that's what it says, yes.
So talking about a realtor code. All right, March 3rd, 2025, 3:56 p.m. Miss Mericle states to Mr. Barron, you had my house key on your key ring. I thought I had given you a key, thank goodness. Correct?
Correct.
And this very next message, which is sent March 3rd at 3:57 p.m. You see that?
Yes. Mhm.
What we have here is an image that was sent. Right?
Yes.
Taking a look at that image and comparing it to Defendant's Exhibit 2, previously admitted.
Okay. I mean,
The Kia keys that were found inside of Mr. Barron's pockets at the hospital. Right, that's what Defendant's 2 is.
yes.
Okay. Mr. Barron states on March the 3rd, it's working properly now. You know what it is he's referring to? It's working properly?
Making an assumption, I would say her horse.
She says that's weird, but I'm glad. Thank you. There's a hay in there. Now, March the 4th, if Thursday is the 6th, if Thursday is the 6th, the 4th would be Tuesday, is that right?
Correct.
7:31 a.m. Mr. Barron is reporting back to Ms. Mericle, I'm in the car and the blower won't come on. Correct?
That's what it reads.
She says, have a good day, sorry the car would not start. And then Mr. Barron responds March 4th, still that same morning, Tuesday morning, in an Uber going to rent a car. Correct?
Yes.
And you're aware of some other evidence that he went and actually did rent a car?
Yes, I believe so.
I did get a rental car. She was offering to actually pay for it. And he says, you're not to reimburse me. Don't feel bad. It's much easier. Okay? Let's move forward to March the 6th. March the 6th again is the Thursday before the Friday of March the 7th. The shooting, March 7th, March 8th. We'll talk about timeline a little bit, but this would have been the Thursday right before, right?
Yes.
Ms. Mericle sends a message to Ms. Barron, I'm going to call the one in Beaufort and see if I can bring the car in Friday, if we can get it started. Right?
Yes.
And then March 6th, Ms. Barron says, they told me how to activate so we can take tomorrow. And that would have been 3:16 p.m. We're getting closer. Here we are, March the 6th, 2025 at 9:12 p.m. This again would be Thursday evening, right? March
Yes,
6th.
9/12, yes.
Thursday evening. I'm 30 minutes away from the house. You want to meet me somewhere to eat? By Ms. Mericle, correct?
Yes.
Mr. Barron responds, Taco Mac will serve till midnight. Can just meet you there. Correct?
Correct.
Text me the address, please. It's a response from Ms. Mericle.
Yes.
And then there's a message sending probably some sort of an image about the address we presume. Is that fair?
Yes.
And then he gives her some further instructions, take the left off I-85 for shopping center on the right. That's at 9:17 p.m. on March 6th. Correct?
Correct.
Now, March 6th at 9:17, thank you. I am here, 9:32 p.m. Correct?
33, yes.
Then there's no other messages between the two of them, because she's now made it, right? She's in person when she gets there on March 6th.
Okay, yes.
And then the very next message after that break is on March the 7th, 2025 at 11:01 p.m. Correct?
This is the message I'm looking at, yes.
Yes. It's a Facebook share, right, with an image on it. Correct?
Yes, I believe so. I mean, it looks, yeah, it is Facebook share, yes.
And do you know what her daughter looks like, Mary Madden? Would you be able to identify her?
I think I saw her in one of the hearings one time.
Okay.
And no, I've been wondering if she was here all week, and I do not.
You wouldn't be able to identify a person in that photo if you don't know what she looks like.
No, I do not. I do not.
11:01 p.m. A message from Ms. Mericle, Mr. Barron, on March 7th, 2025. Correct?
Yes.
Was not admitted, is that right? I didn't do 16. These are, this is 12.
Yeah,
That's 10. 11. 2 seconds up here. Jeff, can we switch back to the audio and video? Play of the little, these are attended.
Hall County 911, address of your...
States exhibit.
Did you say states one?
States 1, Judge, previously admitted. 516. You can go there. You can make it up just a tiny bit. Go ahead. 516.
Hall County Dispatch, how may I help you?
Hi, I need to ask someone to do a welfare check on my sister.
This 911 call's not been authenticated or admitted. This is not Miss Mericle.
This
This
is
is hearsay.
this is the same exhibit the state tendered and filed a
We tender.
pre-trial notice of a business record. It's been admitted in its entirety.
No, I'm not saying that.
Oh, hang on.
Certainly subject to being wrong.
Okay, so there's an argument, excuse me, regarding this 911 call. Okay, so there were actually, I think, and there's like 3 people who called 911. Okay, or maybe 2. Miss Mericle, who's the defendant, and I believe, no, because there's 3, her sister. Okay, the issue, I think, is that the state believes that, first of all, it hasn't been authenticated, this 911 call they're attempting to play. And second of all, it would be hearsay. So because they're not present, they're not in the place where the emergency is taking place, right? So if they're the ones calling 911 and saying what's going on, it's because they've been told by somebody else what's going on. So it's hearsay. So let me, they're going to argue about this. I think they argue about this for the rest of the day. I do not think they bring the jury back, but they might. Yes, they do. All right, here we go.
You already got it. You have D16.
Just to answer Coffee and Skeleton's comment and the question in the chat about trying to get a cat who won't eat wet food to eat wet food. The only thing that I can think of is mixing the wet food with the dry food, and maybe they'll do it. And I know that some vets will recommend giving cats wet food, not frequently and only a small portion, because some cats are not good about being water drinkers, and it helps them with their kidneys.
So that should be 16. You finished on 15.
So you have this is
16 to 20.
where is the yes, missing some, but these are photographs I took.
And those are the photographs you took of Miss Mericle on March the 8th, 2025, at the end of the interview or during the interview?
My timestamp's about 6:30, 6:31,
6:31 a.m.
between the two.
Okay. And do those fairly and accurately represent how Miss Mericle appeared to you on March the 8th, 2025?
You're missing some of the photos.
Yes. Do those photos,
On the bottom side, yes.
with respect to every one of those, do they fairly and accurately represent?
This is the exact photo I took, yes.
But do they fairly and accurately represent Miss Mericle on that date, March 8th?
Yes, they're the ones I took, yes.
Okay. Moving to tender. Defendants lost the number to
Sorry,
ours.
so much more I'll take these.
Any objection, state
No objection to those photos. No.
admitted, and just read what numbers you are again, please.
The numbers are 16, 17, 18, 19, and 20.
Admitted.
I'll show you on the Elmo, I want to show you defendant 16, okay? this would be the right-hand side here. Sorry, the left hand of the picture is Ms. Mericle's right forearm, right?
Yes.
In other words, she's like this. She's got her right arm on the right, she's got her left arm on the left.
That is correct.
And we can see what I'm going to call a reddish, dark red mark on that upper right arm, correct?
Yes.
And looking at defendant's 18, looks awful like 16, doesn't it? Looking at defendant's 17, we can see that same upper arm mark, slightly different angle, right?
Yes.
And defendant's 19, that same mark, slightly different angle.
Correct.
Show you what I had. Which one is? I'm going to show them. First one is? I'm going to show you what had been previously marked as JD1, JD2,
Yes.
JD3,
Yes.
and JD4.
Yes. You've shown me those before.
And I showed you these before in this courtroom when you testified.
Yes. Yes.
And I asked you if those fairly and accurately represented how Ms. Mericle appeared on March the 8th, and you said yes.
Under the limited information with a few photographs I've had, I was able to look at photographs from other angles, and I do think I misspoke on a photograph or two.
Say that last part again. You think you?
I was ill-informed and I made a mistake and I misspoke. I don't think that there was some of the photographs that I took that don't depict some of the bruising further up the arm.
Okay. What you mean is you testified previously that these certain photographs did depict how Ms. Mericle appeared on March 8th, but subsequent to that, you don't believe that they do?
No. You showed me a few photographs, and it didn't sit well with me. I felt on the spot. And then I went back and looked at the totality, which is why I'm asking for the totality of the photographs I took, so we can talk about that.
Do you disagree that you previously testified that JD1, JD2, JD3, and JD4 did fairly and accurately represent how Ms. Mericle appeared on March the 8th?
I do agree that I did say that, and I was hesitant at that point, and I do regret that.
You regret it now?
Yes.
I'm going to tender defendants JD1, JD2, JD3, and JD4.
And Judge, maybe approach?
Hold on.
For what purpose?
I'm not asking the approach.
I mean, I guess.
No, I'm asking you, what are you you're tendering for what purpose? And don't display them to the jury.
That
Thank you.
they fairly and accurately represent how Ms. Mericle appeared on March the 8th, 2025,
Okay.
which the witness has testified that he previously affirmed.
Okay, y'all come up.
Let's just skip on through the regerts, shall we?
Doing their job, thank you.
I will say this. I think that the jury, because I think this way, if I were on the jury and I was, let me put it this way. If I were on the jury and I was listening to this bit of testimony right here, where the cop, the detective says, I was hesitant and I did testify to that, but now I have regrets, but I regret it. I think that that's honest testimony, and I would find that credible, because I do think that what he's saying is that there's some photographs missing. So I think that's important. And I think that goes a long way with jurors, because once again, yes, jurors are allowed to use common sense when they go back there.
On February the 18th of 2026, you appeared in this courtroom as a witness.
Yes.
You were under oath.
Yes.
You took the same oath that you have taken today,
Yes.
and that is to tell the truth and the whole truth.
Yes.
And-
Yes, that's what I tend to do, and that's why I'm saying what I'm saying.
And you were presented with JD1, JD2, JD3, and JD4, correct?
If those are the numbers, I don't recall. Yes.
That's a yes.
Yes.
And you examined those photographs?
Briefly looked at them, yes.
Sure. I said, would you take a look at these? I'm going to show you some pictures, okay?
Yes.
And then I said, defendants 1, defendants 2, defendants 3, defendants 4, defendants 7, defendants 6, right?
Yes.
And I asked you if these photographs accurately and fairly depicted how Ms. Mericle appeared on March the 8th, 2025, when you interviewed her at the Law Enforcement Center.
I was very hesitant, and I didn't have all the photographs that I took to be able to make a comparison. They weren't the same angles.
But that wasn't my question. What I said to you was, quote, just to be clear, defendants 1 through 7, that shows how Mr. Mericle appeared. They may have been taken by you or somebody else, but the point is, this is the way she appeared on March the 8th, 2025, when you interviewed her at the Law Enforcement Center.
And then there was objection, and yes, I shouldn't have answered that question, but I guess I felt on the spot, and I thought there are consistencies between the photos, but that is not how she looked when I interviewed her.
That's not my question. My question was, when I said to you, the point is, this is the way she appeared on March 8th, 2025, when you interviewed her at the Law Enforcement Center, your reply, sir, was yes.
Just to be clear, are we talking about the photos that are up now or the other photos
The photos, including
Yes, okay.
JD1, JD2, JD3, and JD4.
Like I said,
Without displaying to the jury, please hand them to the witness.
Yes.
Just hand them to the witness.
These are the photos,
Yes.
right?
Yes.
And I said, do these depict how she appeared? And you answered yes.
So I was looking at the bruising on 2 of the spots. This one threw me off because you gave me limited photographs to compare to, but the JD2 and 1 really confused me, so I did further research. Yes, the bruising is far more advanced than it was on the 3 and 4 than it was at my time, but my problem is JD1 and 2.
Was my question, do these relate? Do they actually show how she looked on March 8th? And was your answer yes?
Unfortunately, at the time, yes.
And today, you're saying your answer to that exact same question under oath is no.
I was not prepared for that. It's the first time I've seen the photos. I made a hash statement, and I didn't have time to actually go through and evaluate them with the other evidence at hand.
It's nice to have all the information before you get asked questions, isn't it?
It would be yes.
It absolutely would be. If you don't have all the information, you can make a mistake.
Yes.
Asking you more questions about JD1, JD2, JD3, and JD4. You know that these were taken the next day after your interview with Ms. Mericle.
I believe you told me, yes, you alleged that they were taken from an attorney at the jail.
And you don't disagree with that.
I have no reason to disagree with that.
You're not telling this jury that these photos are from 2 weeks after March the 8th.
All I'm disagreeing with is the markings versus my photographs that I took compared to them. Only thing I'm disagreeing is the location between my photographs and JD1 and JD2.
Okay.
That is the only disagreement I have. Yes, when you said look the same, I was talking about 3 and 4's location, the bruising, but I wouldn't say they look the same. But they are same location is what I was testifying to.
Bruising in the location in the arm is the same on this photo here.
What can I say?
Yes, sir.
With
this photo.
in respect to some of the photos you gave me, yes, but not some of them.
Are you contending that there was some sort of fakery of the injuries that are depicted in JD1, JD2, JD3, and JD4?
Absolutely not. Absolutely not.
Okay. What you're saying is, I can't say she looked exactly like that on March 8th.
What I'm saying is I didn't have all the information to my photographs because you presented me with a limited select few photographs, so I cannot see the tops to compare JD1 and JD2, and those are the 2 I'm disputing. They don't look the same. Well, they don't. The bruising coloration is different, but I'm not arguing 3 and 4 locations. I'm not arguing that at all.
Are you arguing any of the locations on JD1, JD2, JD3?
I'm just saying on my photographs, the ones that I took at the time of the interview, I did not see bruising where JD1 and JD2's locations are, and that's.
How are you purporting that those injuries got to JD1 and JD2 that you don't see?
Well, the bruising pattern does take time to take effect. And I'm not saying they weren't there. I'm just saying that they're not the same as the photographs I took, is what you said.
Okay. You would agree with me that the injuries to Ms. Mericle's arms, or forearms specifically, left and right, those are significant looking bruises.
They're very bruised looking, yes. Now, significance is a relative term, but yes, they are bruised.
Fair enough. You would agree with me that something or someone certainly caused the injuries to Ms. Mericle's left and right forearms.
Something would have bruised them, reaching through the door. There's several things that could have done it.
Is it your contention that the injuries to Ms. Mericle's left and right forearms were caused by her striking the door with her forearms?
That, in the interview, she does make statements about that, and I don't know. I wish she would have been more willing to talk about other things that you're alleging. But
well, we know from the text messages between Ms. Mericle and Mr. Barron that Ms. Mericle arrived on Thursday, March the 6th, and that this event was early morning hours of March the 8th, right?
yes,
Did you undertake any investigation to talk to anyone who may have seen Ms. Mericle on March the 6th before she came to Hall County, and whether she appeared bruised or injured?
I believe everybody was so far away that, no, I did not go to St. Simon's.
Fair enough. Do you contend that any of the bruises or injuries to Ms. Mericle's forearms were caused by something that occurred prior to March the 6th of 2025?
In the interview, I did ask if they were older.
Do you contend today whether those injuries were from something that occurred prior to March the 6th of 2025 when she came to Gainesville?
No,
In other words, it is not your theory that these came from some other place than 4238 Bay Ridge Drive in Hall County on either March the 6th, March the 7th, or the early morning hours of March the 8th.
I'm not saying it happened any other place. I'm just saying that the progression is different between the groups of photos, and that's what I was wanting to clarify in the location on two of the photos compared to the others.
Judge, I will move at this time to offer defendants JD 1 through 4. For what purpose? For offering it as evidence of how Ms. Mericle appeared on March the 8th of 2025, and the foundation for that would be the statements of the witness admitting that he previously testified under oath that they were in fact representative and fairly and accurately represented Ms. Mericle on March 8th, 2025. I know he's saying something different today, but of course it would be admissible as substantive evidence as impeachment, and we ask the court.
Well, there's two different steps then. So as not commenting on the evidence and not commenting on testimony, you've not laid the prototypical foundation for those photos. So that's prior objection is sustained. As far as impeachment issues, then I'll hear from you on that. Again, making no comment one way or the other.
The witness has testified, he previously testified under oath that they did. In other words, that they were fairly and accurately represented Ms. Mericle on March 8th, 2025. That is impeachment. It's a prior and consistent statement. It's admissible as substantive evidence. It's admissible as foundational evidence as well. In fact, it's not even a weighing situation, respectfully. It's just, has the statement been made in an admissible fashion? And it has. So it goes to weight. That's what cross-examination is for, or direct.
So Judge, there's no need for any sort of extrinsic evidence. The witness has not denied his prior statement. These photographs are not a prior inconsistent statement. The photographs, they're not a statement. He's already questioned and cross-examined the witness about his previous statement. The witness has admitted to the prior statement and is explaining why that statement was made and why his answer might be different today. So there's no reason to put in photographs to prove a prior inconsistent statement that the witness has already admitted to. So again, there's been no foundation laid for these photographs, and I would object to them being admitted for any reason.
Defense has the last word.
Sarah, maybe sorry for the afternoon.
All right. Again, not commenting on the evidence for purposes of the photographs. They will not be taken into evidence by the court, nor displayed to the jury through this witness.
You know what I'm curious about, Nate? Nate said, me too, Jen Lou. I want to see if they are fingertip bruises from being grabbed or self-inflicted from pounding on the door. I do as well. And I'm curious if we're going to get to that. You know what I mean? It's obviously not going to be through this witness, but I would absolutely like to know.
Those are my questions. Thank you.
Any redirect from the state?
Yes, Your Honor. Are these the ones that, these are, okay. Okay, thank you. Investigator Mefford, talking about the body cam, Deputy Thomas's body cam, did you witness the defendant doing anything with her limbs that could have potentially caused bruising?
Well, I mean, she was going to the ground, flailing about,
Did you ever witness her, like
on herself on the wall.
leaning up against the wall with her arms, forearms, anything like that?
Yeah, she was going to the ground, to the wall, yes.
What about in your interview with her? Did you ever witness her hitting her limbs against anything in the interview room?
Yes.
That is true. She was making excellent use of the space for the dramatics.
Can you tell me about that?
Several times during the emotional theatrics outburst, And especially after I told her that he was deceased. She'd go to the ground, stand up, go to the corner. At one point, she did her arms on the wall. Yes.
And we know that in the door, there are a couple holes in the door. Do we know if she used one hand or one arm, both arms, to reach into the door to try and unlock it?
Trying to clarify, I know she stuck an arm through the door. I don't remember the quotes about how she went through or one arm or both arms, but I do know she stuck an arm through the holes in the door.
So, like, for example, states 225, Judge. Are you able to flip it, or how does that work? Oh, there you go. States 225, we see this mark right here.
Yes.
Do you know how she potentially got that mark right there on her wrist?
I believe in the interview she did say it was through the door.
Do you know whether or not is it possible that she could have also at some point reached this arm through the door to try and unlock it?
Yes, that is possible.
And so I'm going to show you states 224. We see a bruise right by the wrist and then higher up on the forearm.
Yes.
Do you know for a fact how those bruises got there?
No, I do not know for a fact how they got there.
Did she ever state whether or not she only reached this arm into the door, whether or not she could have also reached this arm in through the door?
I know we talked about it at some point in the interview, but I can't remember the specifics. I can go back to the transcript and find it, but she did talk about reaching through the door.
Do you know, I know that sometimes pictures like mirror things. Do you know which arm is her right arm and which arm is her left arm?
This.
So like the one with the bracelet, which arm is that?
That's her left arm.
And then this would be her right arm?
Yes.
Okay. I want to ask you about, so Mr. Willis kind of talked about on scene in the body cam with Deputy Thomas that one of the officers tells the defendant that Mr. Barron is still alive. Do you remember that discussion with Mr. Willis on cross?
Yes.
And do you remember, Mr. Willis was talking about basically her statements before and after she found out that before when she thought Mr. Barron was dead versus after when she thought Mr. Barron could potentially still be alive.
Yes.
Do you remember talking with Mr. Willis about that?
Yes.
And there was a mention that on cross that the defendant's statement started to change after she thought maybe Mr. Barron was still alive. Do you remember talking about that with Mr. Willis?
Yes.
Do you still have the transcript from the body cam up with you?
Yes.
Could you turn to page 26 and let me know when you're there?
I'm at 26.
So on page 26, at 1 hour and 5 minutes, is that when Ms. Mericle is told that Mr. Barron is still alive?
Yes, 105:23.
Okay, so this is the kind of the time marker for the switch of he's probably dead to maybe he's still alive on page 26.
Yes, from the verbiage, yes.
So what I want you to do, if you could flip to page 27, at 1 hour and 10 minutes, so this is now after she's been told Mr. Barron's still alive. At 1 hour and 10 minutes, can you read what she stated there?
So 110?
1:10:10.
Okay. He got mad. He wanted me to sell my practice for more and put the money in the house.
So I'm just going to go ahead and count. So that's one time she mentions him getting mad. If you could go down to 1:11:53 on that same page, can you read what the defendant says there?
He put his gun right to my mouth. He told me not to go. I better not fall asleep.
So number 2, she's mentioning him putting the gun to her mouth after she believes Mr. Barron's still alive. If you could read at 1:13:30, what's said there?
Tonight, the last time he got like this, I called his son. He told me tonight if I called his son, he would kill me.
So that's a threat. So we're going to count that as number 3 times that she has talked about Mr. Barron threatening her. If you could flip to page 28, at 1 hour and 17 minutes and 30 seconds, if you could read what the defendant says there.
When he hit me across the face, I think we may, when he hit me across the face, I think we may have great families. We're good people. Peace, God.
So that was number 4. He hit me across the face. If you could flip to...
You might have to object at this point. That transcript was prepared by AI. I handed it to the witness to assist him. It's not accurate. I think they need to play the video instead of relying on the transcript. The reason I played the video and gave it to the witness so we could rely on actual evidence, which is the video. So I don't have an objection to them playing the video, but to just read the transcript, I object.
That's fine, Judge. I'll play the video.
Uh-oh. Not AI. I'll say this. To be fair, there's a lot of caterwauling, and I have the closed captions on, and the closed captions don't always get it correct, especially when she's hollering, whooping, and panting like a dog. And I believe I remember that part, and she says, oh God, she doesn't say peace. She says, please.
You ready?
It is loading. Now I'm ready. Yes, Judge. So we're up to 4, investigator Mefford, after she believes that Mr. Barron is still alive. I'm going to fast forward to 1 hour, 32 minutes, and 58 seconds.
Let's just have a moment before we have to listen to this caterwauling and the panting. Okay. I have to say that I think that this attorney, the prosecutor, is doing a fantastic job of closing up any potential little holes of reasonable doubt, because the defense's assertion is that the reason that she did not admit to being hit or telling the full story of all of the abuse that she suffered, allegedly, that's what she alleges, under at the hands of Mr. Barron was because she thought Mr. Barron was still alive. And she's going to play the receipts of all the times that she admitted to prior instances of potential of abuse when she thought he was still alive, closing those little tiny holes that could possibly be reasonable doubt.
He was going to do something to him. I'm going to start playing at 1 hour, 32:48. Oh, baby, be okay. Be okay. I should have told him that I was breaking it off. I was scared. He was going to do something to himself in there. He was going to hurt me and then hurt him. So did you hear her say, I was scared he was going to hurt me?
And then hurt him?
And then hurt him?
Yes.
Okay, so on my count, that was 5. I'm going to skip to 137:58. I'm going to hit play 137:55. When he got mad at me, I should have just left, but I was scared because the last time he got mad at me, and I left, and I was so upset. So right there, she's talking about being scared to leave.
Mm-hmm. Because the last time he got mad at me and I left him, I was so upset.
And then I'm going to skip to 147:47. I'll start it at 147:30. When he told me, guys, I should have just left. I said, open the door and put your gun outside. So, right there, did she say, when he told me not to go to sleep, I should have left, and then she says, I said, open the door and put your gun outside?
Yes.
My count is that 7. I'm going to go to 149. I'll play at 149, 21. I should just went downstairs and just left. I was scared to leave. I said, we've gotten so many fights because of this. I should have just put that gun to my lips. So right there, did she just say when he put that gun to my lips?
Yes.
And again, did she also talk about being scared to leave?
Yes.
And then at 151, I'm going to play at 151:04. God! Oh, God! Oh, God. I was scared to go to bed. I should have just left. I guess. So right there, did she say I was scared to go to bed?
That is correct.
And again, are all these statements made after she believes Mr. Barron is still alive?
Yes.
I'm going to skip ahead to 2 hours and 16 minutes.
Nate Noodle, do you know this because you have watched ahead? Nate, are you cheating? Now, I know that I watched ahead, but that's research because I'm the hostess. Did you cheat? Oh, neat.
I'm going to play at 2 hours, 15 minutes, and 50 seconds. So, and I stay there all night.
So now I want to go to my house, and I want to go to jail.
And then tonight, he threatened me, and I should have left, but I was scared. Sorry, there, did she say tonight he threatened me, and I should have left, but I was scared?
Yes.
And then I'm just going to keep playing. I'm going to hit play again at 2:16:10.
I want you to tell me all about that.
I'm not scared. I just don't know what happened. He put that gun on my lips. Sorry, there, did she say he put that gun on my lips?
Yes.
I'm going to hit play again at 2:16:40. I just had a really bad this year.
Okay. So like I said, I want to talk about every bit of that. So
I don't want to talk about it.
They did play some of this, but some of this I feel like they didn't, or else my mind has deleted it from the files due to trauma overload. I'm sorry I accused you of cheating. Sorry.
Everything was fine.
Everything was fine until I accused Nate of cheating.
Whoop, it froze. Give it a second.
I think I'm broke the player.
Right there, did she say he shot the gun?
yes.
So, in your interview with the defendant, again, when do you finally tell her that Mr. Barron is deceased?
Towards the very end. I don't recall the exact time or hour, but I know it was. So, in a 61-page transcript that I have here, it is on. 66-page transcript. On a 66-page transcript, it's on page 61.
And so, basically, the very end of your interview is when she finds out that Mr. Barron is deceased.
Correct.
So, the entirety of your interview up until that point, is it your understanding that she still believes that Mr. Barron could be alive?
Only thing I told her that I did not know. They're working on the hospital. I did not know at this time either that somebody said yes, but yes, he could have been, or it could not have been. I mean, she's also the one that said she couldn't feel a pulse, so.
But no one's told her. So since that officer told her that he left the scene still alive, nobody has told her differently at that point?
No.
So I want to now ask you just a few questions about your interview. Judge.
Thank you, Chicken Lady, for becoming a member. Again, I appreciate that. Would you guys like me to cover the Kelsey Fitzsimmons trial next? Should we do a poll? Let's do a poll. Okay, here we go.
If I could have I think it's up on the TV and I can't see it. Oh, there we go. I'm going to skip in your interview to 2 hours, 36. $236. We'll start here. I'll go back 10 seconds. I'm going to start it at 2:36:26. So when you leave, and now Sergeant Cuneo stays in the room, does the defendant talk about Charlie English?
Yes, I believe that was the first mention.
I'm going to hit play.
I haven't been to the house. I haven't been to the hospital. I came in to meet with y'all.
I pray. I know better.
Right.
It was a stupid phone.
There's nothing on that phone that you don't want him to see.
I mean, this guy was texting me, but nothing, I told him that guy texting me.
Nobody like you're seeing.
So, if you can, what does the defendant say in response to there was this guy texting me? What did she say after that?
I told him about this guy texting me.
So
So does Ms. Mericle ever say that he saw the texts or he found out about him and got really mad, anything like that?
Not that I recall, no.
So she tells him, Sergeant Cunha, I told him about Charlie English.
Yes.
Is there ever any mention by the defendant at all that Mr. Barron was angry because of seeing text messages from Mr. English?
I want to say there was some, I don't recall. I don't want to answer that question because I don't want to misspeak again and I want to be back, but not that I recall, but I'm trying to think, was there? No, because she was telling me at first that there was nothing on her phone. To my knowledge right now, I think this is the first mention of it. Now, what was your question? I'm sorry.
Just besides this mention of Mr. English, is there really any other mention of Mr. English throughout your interview?
No, Mr. English himself, no.
And in this moment when she's talking to Sergeant Cunha, does she mention anything about Mr. Barron being angry about Mr. English?
No.
In fact, she says that she's the one who told Mr. Barron about Mr. English.
Yes.
Lastly, I just want to go back to 205. Is it normal for individuals to be nervous when they're being interviewed by investigators?
Yes, when they first come in, that's when we like to establish that baseline, build a report, so we get a baseline function.
Sometimes, have you ever, when you're interviewing someone in a setting like this, seen someone kind of like shaking out of nerves?
Yes.
I'm going to go ahead and hit play at 20507.
Like, say that's the door lock. I walked right up to the door. I think I put it up here. I can't remember if I stopped here, but I shot it right above the door. I know that.
Okay.
I don't know if I...
So, right there, can you describe what the defendant's doing?
She's making a handgun, a gun with her fingers, and pointing towards the little outlet cover in the interview room.
Crafting in True Crime, Jacqueline says, I have a confession too. I watched yesterday's coverage of this trial. Side eyes is all I will say. I do know what's coming up on day 5. The difference between me and you is that I do it for research for the channel because I'm the hostess. Y'all out here just cheating on me. I'm just kidding. It's too much.
Is she demonstrating how she fired the gun at the door?
Yes.
Is she moving her hands up and down at pretty much 8.5 inches to demonstrate how she fired the gun at the door?
No.
I don't believe I have any other questions. Thank you.
I don't have any further follow-up questions for Ms. Goodall.
Thank you for your testimony. You can return to counsel table.
State rest, Judge.
State rest.
Okay. The state's rested. Obviously, what comes next, but I don't think that they do it on this day because there's only 5 minutes left and there's no way they're going to be able to, well, I mean, there's 10 minutes left, but I don't think they're going to be able to make that argument in 10 minutes. They're going to move for a directed verdict. Let's just, thank you, Justified. You will get an extra star for that. Justified said, I is loyal. I know watching. I appreciate that. I mean, will this betrayal never end? So, Crafting in True Crime says, Jacqueline says, of course, without all of you and Jen's explaining, I don't know what they were explaining when the court was arguing before lunch. Daria, what up? Good to see you, babe. All right, I'm going to check this poll.
At this time, I think we need to address the court.
90%.
Please. We're going to discuss scheduling.
I guess the people have spoken. Hold on, let me look at this. Except for only 10 people voted. There's 27 of y'all in here. Go vote in the poll. Okay, now there's 23 of y'all in here. I don't know why 4 of y'all left, but there's 23 of y'all in here. Go vote in the poll. Come on. Why is only 10 people voting? I'll cover whatever you guys ask me to cover. I must admit, I'll have to do a little research. I'm not highly... Hold on.
I legally required to...
I'm not super like up on that trial. I don't know all the deets, but I can look.
Speak with the lawyers, which we'll do outside your presence. And short version is we're going to call it a day for your services. We will need you to come back tomorrow if the state is arrested. We'll do some lawyer stuff in the interim, and we'll start back again tomorrow morning. Should there be anything to start back, and then so 8:45 start at 9, and we'll go from there. All right. Again, please do not discuss case with anyone. Do not do any research, in person, online, AI, none of that stuff. Thank you. Don't discuss case with your family. Do not discuss case with your family. Thank you. Y'all are excused.
Okay, so Crafting and True Crime Jacqueline says, I find the cop trial interesting for many reasons, but also because she requested a bench trial. Okay. I love a bench trial. Here's why. More things can get said because it's not in front of a jury. Okay. That's number one. Number two, bench trials are interesting. We watched a bench trial, Henry Dinkins. He was convicted of murdering his stepdaughter. She was Breasia. She was young, 9 or 10, I think, maybe 8. And I guess that wasn't really his stepdaughter. She was his son's half-sister. It's very convoluted. The playlist is on my channel if you want to check it out. It's a very, very sad case. But I believe that the reason that he requested a bench trial was because the murder of a child is highly, highly emotional. And I think that he wanted... How do I put this? I think what he wanted was a judge that would not use their emotions. Oh, really neat. Neat said, I think she will be done today. It was only supposed to take 3 days. All right. Well, whatever. However, we'll cover that one next because we'll be behind. This one is still going on. They're on day 6 today.
For today. Y'all need a moment, are you ready to roll?
We're ready, Jeff.
Mr. Willis?
Ready.
All right. Y'all can be seated. We'll potentially be a while. Floor is yours, guys.
I stand corrected. They are going to make a motion for a directed verdict. Here we go.
Thank you.
We're moving for a directed verdict on all counts of the indictment.
Can't quite hear you.
I'm sorry. We're moving for a directed verdict on all counts of the indictment this time. I think with respect to several of the counts, the tampering would be by inference. The malice murder would be obviously by inference as well. Behind a closed door, which is opaque, the testimony's been that no person could see inside. There's evidence about hearing. That'd be by inference. The aggravated assault counts, we believe, has not been met as well, beyond a reasonable doubt. We'll say the same with respect to the criminal damage first. I think I have all the counts. There's also the possession of firearm during commission of a felony, which...
Your counts are malice murder, felony murder ×2, aggravated assault, criminal damage to property in the first degree, felony grade, possession of a firearm during commission of a felony, and then tampering with evidence, misdemeanor grade.
And I would... The tampering charge, I think, is the strongest charge. Respectfully, we'll move for direct verdict on the remaining counts.
Not to quibble with you, nor take anyone's side. On count 7, you said you believe that might be the strongest one. Walk me through that.
Well, it's still by inference, but there's the only person who could have flushed shells, spent shell casings, it would be Miss Mericle, it would seem. So I think that might be their strongest count. But as is our duty, we're moving for a directed verdict on all the counts.
Noted. Thank you. State.
Yeah, sure. Just that Your Honor knows that the burden for directed verdict is just that there's some evidence as to each count, all the elements in each count. And state's position is that there's been more than enough evidence presented to reach that burden as to each count. I don't know if I need to go through each count to talk about all of the evidence that the state, but I mean, as to the malice murder, obviously, no one's arguing that Mr. Barron's not dead. No one's arguing that Ms. Mericle did not shoot him. So as to the malice, there's been plenty of evidence to show the malice, the walking up to the door, aiming, firing, and then staging the scene after the fact, Googling the Hall County Jail beforehand, all of the text messages. There's been plenty of evidence to go to malice as well as intent, malice, which is the intent to kill, to show that Ms. Mericle did, in fact, aim through the door in the direction of where she believed Mr. Barron to be, that she intended to shoot Mr. Barron and kill Mr. Barron. As to the aggravated assault and the criminal damage, which are the basis of the felony murder, there's been plenty of evidence shown that, again, as to the aggravated assault, that the defendant had a firearm that she offensively used by firing the firearm in the direction of James Barron that obviously ultimately resulted in his death, as well as the criminal damage to property that there's been plenty of evidence shown that she did interfere with the door knowingly and without authority interfere with the door, and that it was in a manner that endangered human life by shooting into a room that was occupied by Mr. Barron. There's been no evidence to say otherwise, other than she knowingly fired that firearm through that door and that it endangered Mr. Barron as well as ultimately killing him, as well as the possession of the firearm during the commission of that aggravated assault. And then, as Mr. Willis said, the tampering with evidence, there's been plenty of evidence to show that Ms. Mericle did walk over to the toilet and flush the casings and the bullet. So as to all counts in the indictment, Judge, I would ask that you deny the directed verdict.
Last word, defense. Anything?
Nothing further from us, Judge. Thank you.
All right, court's going to deny defendant's motion on all counts. The state's met its burden as far as this stage of the proceedings go. Certainly reasonable jurors may agree or disagree, and certainly that's why we have the beyond a reasonable doubt standard and also their deliberations. But the state has put forth sufficient evidence to get past the defendant's request, and therefore defendant's motion is denied as to all counts. We will pick up tomorrow, same time. Dr. Mericle, you have the right to testify or not testify as you so choose. Silence cannot be used against you. If you wish to testify, great. If you don't wish to testify, great as well. Please understand you should certainly consult with your lawyers regarding this potential decision, but ultimately it's your decision and your decision alone, regardless of what your attorneys say or do not say, and that's none of my business. I'm not getting into that, but ultimately it's your decision to make. I don't need a response from you at this point, but I did want to make sure that I again advised you of that. Anything from the state?
No, Your Honor.
Anything from the defense?
No, sir. Thank you.
All right. See y'all tomorrow.
All right, here's the deal. I will compromise with you guys, and I will stay live till 2 o'clock, and we will watch a little bit of day 5 when she takes the stand. Only because, hold on a minute. You must have had the cameras on. No, I'm going to watch. I feel like we should. Yeah, this is way better. Let's watch this one. Only because I'm curious too, and I haven't seen this one. But I can only stay till 2 because I did promise the Nuggie that we would do some outside time. And she's been very, 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 very patient. So, all right. Let's close this. Let's put this one on. Hold on. There's no closed captions. Nope, can't do it. The audio in that trial is too caca. We will definitely be starting over here. There's no closed caption on this one either. All right. Hold on. All right, here we go. You're welcome because I love y'all so much. All right, here we go. But I am going to speed her up just a tiny bit. Just a tiny bit. All right. I mean, this is a 10-hour long live. And it seems like It's her all day, I think. All right, here we go.
Go ahead and introduce yourself to the jury.
Okay, hi. I said my name is Suzanne Mericle.
Before we get started, I wanted to ask you, can you hear me now, Judge?
Yes.
Before we get started, I wanted to ask you about whether you're taking any prescriptions right now.
Yes, I am.
Okay, and do you know what all those are as you sit there, or do you need to look at a list to kind of
I
remember
need to
those?
look at a list.
Okay. Can I approach the witness, Judge?
Yes.
Okay. I'll show you those, okay? Can you take a look at those and tell us what you're taking now?
Yes.
Can you tell us what medications you're on right now?
Yes, I'm on vitamin with minerals, prednisone 2 milligrams, trazodone 100 milligrams, Seroquel 100 milligrams, hydroxyzine 50 milligrams, estradiol, ibuprofen, citalopram, HBr 40 milligrams, and risperidone 2 milligrams.
Okay.
Mr. Van Rossum, lawyers, come on up.
Suzanne, you have the ability to turn down the volume on your.
Turn it down.
Yeah.
Try that.
Okay, I'm talking now. Go ahead.
Okay.
Can you still hear?
Yes.
Is that okay? We getting feedback over here? Judge, is that good?
We shall see.
Okay.
Okay. Sorry.
I wanted to show you some pictures, Defendant's Exhibit 21 through 41. 21 through 41. First witness. I'm going to show you Defendants 21 through 41, okay? You can take a look at those and see if you recognize those.
Yes,
You recognize all those?
I do.
What are those pictures of?
They're pictures of me the day after the incident happened,
On March the 8th?
on March the 8th.
Do they fairly and accurately represent how you appeared on March the 8th?
Yes, they do.
Move to admit Defendants 21 through 41.
No objection.
Admitted.
Yeah, I'm going to show you Defendant's Exhibit 21. Which, can you tell us which arm that is of yours, your left or your right?
It looks like my right arm.
Okay. I'm going to show you Defendant's Exhibit 22. Is this another picture of that right arm?
Yes, it is.
Defendant's 23. What is this a picture of?
Can you talk in the microphone?
What is this one a picture of? Is this your same right arm?
This is my same right arm, yes, the underside of it.
Okay, I'm going to show you Defendant's 24, okay? What is that?
That's my left arm.
What does this show in defendant's 28?
That's on my knee.
And which knee is that?
It is like my left knee.
And defendant's 29.
And that's my left thigh.
Defendant's 31 here.
And that looks like my left thigh again.
And defendant's 33 here.
It looks like my thigh.
Is this your left or your right?
It looks like my right.
And defendant's 37. What does that appear to be of?
It looks like a picture of my left arm over my right arm.
And defendant's 39.
And it looks like my right arm.
Defendant's 40.
And that looks like my left thigh.
Adjust it. How is it that you sustained the injuries that we've looked at from exhibits 21 through 41?
It's where he grabbed me and hit me the night of the incident.
Okay. I kind of wanted to go right into March 6th and March 7th, okay?
Okay.
Tell us what happened on the evening of March 7th, around about the time that you all were in the living room and there was dinner being served and all that.
Okay, beginning in the evening, I decided to cook dinner for us. And so I made scrambled eggs for him and a fried egg for me. And I made I cooked some kielbasa and some bacon. I fried the bacon.
Okay.
And then we
You
had
said
dinner.
Kielbasa?
Kielbasa.
Like
it's-
kielbasa, sausage?
Yeah, sausage.
Okay.
I cut that up too for us. And then we had dinner, and then I cleaned up the kitchen. And then he fell asleep.
Where in the house, the jury has seen lots of photos of the house, where in the house was this, where he falls asleep?
In the living room area where the two chairs are, in the foyer area right in front of the television.
Was there something that you did while he's asleep there in the foyer?
Something that I did.
Yeah, he's asleep. What are you doing?
I'm over there on my phone.
At some point, does Mr. Barron wake up?
Yes, he does.
Okay. And what happens after it is that he gets up?
After he gets up, I went to the bathroom, and I came back, and he was awake, and he had my phone in his hand.
Okay.
And
So are we talking at the first place? You have free reign. Thank you, I'm sorry. State's Exhibit 182. Is this your phone?
yes, that's my phone.
Okay. Does Mr. Barron, well, first of all, do you have a code on your phone?
Is he what?
Do you have a code on your phone?
Yes, I do.
Okay, I did zoom in on these bruises, and I don't know. They don't look like grabbing bruises to me, but I'm not a doctor.
Is that something that Mr. Barron knows?
Yes, he knows my code.
What is the code? You don't tell me the number, but what does it represent?
It's my mother's birthday.
You got your mother's birthday as your code, and you've gone into the bathroom now, so you've come back, and Mr. Barron's holding your phone, so tell us what happens next.
Yes, he's holding my phone. And he said to me, he said, who is this guy you're texting? And I said, he's a friend of mine. He said, it sounds more than a friend. And I said, he's a friend of mine. And he said, how do you know him? And I told him that I met him on St. Simon's Island. He said, how long have you known him? And I told him about 2 years. He said, have you ever slept with him? And I said, no, I have not.
Okay. And hang on before you go any further. When was it that you had started, I guess, communicating? Or are we talking about, what's the name of this person, first of all?
Charlie English.
Okay. When was it that you had started communicating with Mr. English by text?
About 2 to 3 weeks prior to this day.
So this would be the 7th. So we're talking about February 15th, 16th, something like that?
Yes.
Okay. Had you actually gone and met in person with Mr. English? Had you had some physical meeting with him?
No, I have not.
You're texting with him, though, and what messages on your phone are visible? In other words, that Mr. Barron could see?
There were only 2 messages that were visible to him.
Okay. And I'm going to try to find them. Do you remember what the substance of the one?
Yeah, the one text said, if you were alone with me, what would you do to me right now?
Oh boy, yikes. To me, they look like what you get from striking something, or from, a blunt instrument. Either you being struck with a blunt instrument, or you striking yourself against a blunt instrument, maybe a door, because just at the one that's on here right now, you see they're all in a line, right? And they're not really, although this is a terrible picture, obvious. It's probably a good picture in the room, but it's not a good picture here. See this bruise right here? See how it doesn't like wrap around her arm? It's just right here. I feel like if somebody grabbed you, you would have bruises all the way around. It's not like she has a very big arm. I feel like he could get his hand all the way around.
Something like that.
Remember what the substance of the one?
Yeah, the one text said, if you were alone with me, what would you do to me right now? Something like that.
I'll show you Defendant's Exhibit 14. See that big green right there?
What would you do to me if I was next to you?
Did Mr. Barron accept your explanation that you'd not had a relationship with this other man?
No, he did not.
What happened after that?
After that, he told me, did you sleep with him? And I said,
Objection, hearsay.
It's not offered for its truth. There's statements involving the heart of this case.
Judge, I can't imagine that these statements by Mr. Barron are not offered for the truth.
What other reason would you offer them to explain why she did what she did next? Are they going to take a break? I think they're going to take a break. Hold on. Let me see what's going on here.
From the top.
Judge, I'm going to object to hearsay. This witness, Mr. Barron, is unavailable because this defendant killed him. And for this defendant to be able to talk about everything that Mr. Barron said that night, they are absolutely offering all of these statements for the truth of the matter asserted. They are offering these statements to show that Mr. Barron was angry about Mr. English, that he didn't believe that she had never met him before, that he didn't believe that he had had a sexual relationship before, talking about statements that he made as far as all of this is hearsay. They're absolutely offering every single one of these statements for the truth of the matter asserted. And to try and get in Mr. Barron's statements, who is again deceased, especially after Judge, we had a whole hearing about Mr. Barron's statements where they wanted to keep his statements out, and the body cam from St. Simon's arguing confrontation clause, but then
Does the state have a right to the confrontation clause?
No, Judge, we don't.
They don't.
They don't.
Okay.
And
so why would you bring that up?
Because the defense
Why would you bring that up? You're making an argument that somehow that ruling related to the confrontation clause is somehow applicable here.
No.
How is it applicable here?
Judge, the only reason I brought that up is because the defense was adamant about making sure that Mr. Barron's statements, and that is hearsay.
They were adamant because there is well-established constitutional precedent that a trial court should not let that in.
Correct. And there's also well-established precedent to not allow his statements in this context as well. And that's why I brought that up, Judge, because if there's well-established precedents for one, there's also well-established precedent for
I'll give
the
you
other.
15 minutes to give it to me. I'll be back at 9:30.
Well, damn. Can I just say this? This judge has been cooler than a cucumber in a bowl of hot sauce the entire trial. He's given these attorneys free rein. They don't have to ask to approach every time. And she, in his mind, in his opinion, in his the way he perceived it, she was calling a prior ruling into question. And it got spicy. All right. So let's see.
Whether or not he was actually going to kill her is
She made this man lose his cool. And we're still muted. Come on, man. I want to hear what the judge has to say. No.
Mr. Barron's statement under residual hearsay.
No, Neat Noodle. The jury was excused.
The times where statements by a deceased victim are admitted under residual hearsay, the reasoning for it that the courts continue to give is because of its significant guarantees of trustworthiness to the person that the statements are made to. So, for example, a domestic violence victim confiding in a friend, a parent, a sibling, something like that. There's significant guarantees of trustworthiness as to that statement, and that's why those statements are admissible. Because this individual, Mr. Barron, is an out-of-court statement. He's a declarant, and he is out of court. He is deceased. And the state's position is that these statements were being offered for the truth of the matter asserted. There needs to be a hearsay exception for these to fall under. The residual hearsay exception would not apply here because there are not significant guarantees of trustworthiness.
Mr. Willis at the bench stated that he was asserting this not for the truth of the matter asserted, that it was not hearsay.
Correct. And I guess that's where we differ, is Mr. Willis believes that these are not hearsay because they're not for the truth of the matter asserted. State's position is that these particular statements are hearsay because they are being offered for the truth of the matter asserted. I'm not of the position that every single thing Mr. Barron has ever said is always going to be hearsay, because of course there are times where there will be admissible statements because they're not offered for the truth of the matter asserted. But specifically statements about what he was saying in regard to these texts with Charlie English are being offered for the truth of the matter asserted because this defendant is offering that Mr. Barron was telling her that he was angry, that he didn't believe her, that they had never had a sexual relationship, that he didn't believe her, that they had never met, all of these things. Those are being offered for the truth of the matter asserted to show that he didn't believe her, that he was angry, that he thought there was a sexual relationship, to go to what they're then going to go into, which is he was so angry he did X, Y, Z to me. All of those statements specifically are offered for the truth of the matter asserted. I don't mean to say that Ms. Mericle can't say anything Mr. Barron's ever said, because of course there will be statements that are not offered for the truth of the matter asserted. That's fine. But I think where me and Mr. Willis differ is simply whether or not these statements are being offered for the truth of the matter asserted, and the state's position is that they were. And so that is why I objected, Your Honor.
And there's so many exceptions for this to come in that it'd frankly be impossible to list them all, but here they are. It's not hearsay because it's not offered for the truth of the matter asserted. This is a self-defense case where Ms. Mericle is asserting that she was defending herself against an unlawful assault by Mr. Barron. She can't possibly make out that matter, can't possibly make out that defense unless she offers up the things he's saying to her while he is attacking her. So it's preposterous to even consider. It has to come in, number one. Two, it's not hearsay because it's not offered for the truth of the matter asserted. If he calls her a SLUT, that wouldn't be offered for the truth of the matter asserted. If he tells her, I don't believe you, if he's angry, if he's moving towards her, these are non-hearsay exceptions. That's why they're non-hearsay. Additionally, they're present sense impressions, 8031, and they're also statements of then existing state of mind, 8033. It's just, you could sit here and go through every single hearsay exception. It's going to meet them all because courts let these things in all the time. You can't fathom a self-defense case where you can't say what the alleged victim was saying to the defendant as they're trying to defend themselves. How else could she make out the fact that she thought he was going to kill her if she can't say, I'm going to kill you, right? The argument starts here. We've moved right up to the relevant time frame. This is not, we're not offering things said weeks ago. We're talking about in the critical times of this unfortunate tragedy. So, A, it's not hearsay. B, it's a present sense impression, 8031. C, it's a then existing state of mind statement, 8033. And D, it's also offered for the effect on the hearer, who is Miss Mericle, who's asserting a self-defense claim and a justification.
Judge, my only response to that is I'm not objecting to them talking about threats that Mr. Barron made. I agree that him saying, I'm going to kill you is not hearsay, because whether or not he was actually going to kill her isn't what they're offering it for. They're offering it to go to her fear. So I'm not saying that they can't get into Ms. Barron talking about threats that, or that Ms. Mericle can't talk about threats that Mr. Barron made. I do agree with Mr. Willis that that would not be hearsay. They're not offering that for the truth of the matter asserted. I'm only talking, so I'm not talking about every statement. Like I said, I'm not talking about every statement that Ms. Mericle may or may not testify to as to Mr. Barron. I'm only specifically talking about these specific ones that she's talking about right now, about Mr. Barron saying he didn't believe me that I wasn't having an affair. He didn't believe that I never met him. He didn't believe me about that. There's plenty of ways that they can talk about Mr. Barron allegedly being upset by these texts without talking about what he said. Did he appear angry after reading those texts? Did he appear upset? You know, what did he do? They can talk about his actions that he took after reading these text messages. All of that would be perfectly fine. Those aren't statements. So, like I said, I'm not making a blanket objection that she can't say anything that Mr. Barron ever said that night, including threats. I do agree that that's not hearsay. I'm only talking about the statements that were just mentioned on direct as far as the text messages with Mr. English.
So, as the lawyers are aware, the Georgia legislature, the Georgia Supreme Court adopted federal rules. We're clearly in 801 as well as 803. I don't think I've received any case law or annotations or anything from either party. Does anyone want to provide that?
I couldn't find any cases where the defendant was testifying as to deceased victims' statements. Anything that I searched as far as deceased victims' statements, hearsay, defendant, anything like that, all came up with residual hearsay where victim made statements to other people other than the defendant, and that they came in under residual hearsay.
And that, I would say, is very instructive. The fact that that's never been appealed shows you just...
Well, in fairness, in making no comment on this case, the state's a little bit hamstrung on these types of cases because there's no right to an appeal, and I'm not saying it either way, of an acquittal. So, it's a situation where, in fairness, and I'm a neutral party, but the state doesn't have a whole lot of opportunity to appeal after the fact.
Right, but it would be a defendant where a trial court said you can't put these in, and a defendant appealed.
Exactly.
And there aren't any.
That was my understanding as well. That's why we took a break, and it's been a half hour, and I appreciate everyone giving me argument, but I've yet to have a case, so that's why I'm asking. The court's ruling is that it is not hearsay under 801C. Even if it was hearsay, you have 803.1 and 803.3, as pointed out by the defense. That being said, I am going to give a curative instruction or an overarching instruction.
I think it would look like this. Crafting and True Crime Jacqueline. This would be the jury's face. Shook.
Members of the jury, I'm not commenting on the evidence. However, to be clear, these statements are
Okay,
not for the
it's
truth.
coming in, blah, 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 blah. Let's just keep going.
3 improper things, or you're entitled to 3. You're entitled to 0 improper things.
Hold
You're
on.
entitled to what the law
Hold on. Maybe I got too quick.
And I'm not saying it either way of an acquittal. So, it's a situation where, in fairness, and I'm a neutral party, but the state doesn't have a whole lot of opportunity. That was my understanding as well. That's why it is not hearsay under 801C. Even if it was hearsay, you have 803.1 and 803.3, as pointed out by the defense. That being said, I am going to give a curative instruction or an overarching instruction.
You've heard this. What, I need to know what that got this judge spiced up again. What happened?
Members of the jury, I'm not commenting on the evidence. However, to be clear, these statements are not for the truth of the matter asserted, but only to potentially explain defendant's actions. It's a pretty important instruction I'll give to the jury.
Judge, I would ask the court not to give that instruction if they're missing under 803.1 and 803.3. There's no need for an instruction.
Well, I'm finding that it is, it's not hearsay. So, but I'm also stating for, and appellate record's not my concern, but there's also logic in 803.1 and 803.3.
So why don't you want an instruction, bro?
We still have an objection to the instruction. We understand the court's ruling.
Okay, well, what's your objection?
Well, we don't think that we should give an instruction about specifically Ms. Mericle's statements about Mr. Barron, because then it's the first witness. There's been loads of hearsay admitted. Mr. Barron said this, there's texts that come in, and the first person that takes the stand, respectfully, when the defendant gets up there, we say, hey, we don't believe her statements.
There's been loads of hearsay admitted. Okay. What does that mean?
Well, it just means the very first witness that the jury's ever told. And I know the court's, I'm not trying to say that, I know you're trying to do exactly what you think's exactly correct. And I think
but the comment of loads of hearsay, see, this is something that if the difference from the court's perspective is that the state has made an objection.
I see.
So if you'd like to compare apples to apples, let's do that. But, and this goes for both sides, and I'm not trying to get on my high horse here, but this is not a quid pro quo. This is not, oh, well, you're entitled to 3 improper things, or you're entitled to 0 improper things. You're only entitled to what the law allows, what the law requires for both sides. If you disagree with it, then you get up on your feet and say the words objection. Judge, I have an objection. I object to this. If you don't object to it, and this goes for both sides, I don't want to hear about it 2 days later. So, loads of hearsay aside, on this objection, what would you like to talk about?
I didn't mean to infer that because hearsay had been admissible, we're entitled to it. What I was trying to
Hold on a minute.
articulate is that
You didn't infer, sir. You implied. And from your implication, the judge inferred.
of all the witnesses who have testified, it may create an impression on the jurors that the first time they're told, hey, the things she says, in effect, aren't, I don't want to create the inference at the police court that you're passing on her believability. That's all I'm trying to get to.
And I understand that's a concern. That's why I'm reading it aloud. And so the state's interest and concern, and again, I'm a neutral party, is that you, through testimony, the defendant will be able to say many, many things, uncontroverted, essentially, not saying it's true, not saying it's false, but they're objecting to it. And the objection that they're making is a good one, but I'm ruling against it and saying that it's not hearsay, that it is not for the truth of the matter asserted. And I'll be honest with you, that was the first thing you said when you came up to the bench, is that you were not asserting it for the truth of the matter asserted. So I understand the concern about the court speaking to the jury on it, but I'm not trying to be rough on this. I'm going to say something to them. So I would appreciate the party's input. And if you don't, that's fine.
May I just want to go?
Yes.
Oh, for the love of Pete.
Judge, maybe be excused for a brief break while
Yes.
discussing.
Good Lord.
And this may be too crude as far as the first part. Hearsay means a statement other than one made by the declarant while testifying at the trial or hearing offered in evidence to prove the truth of the matter asserted. And this may be too broad, I understand. The court has ruled that this line of testimony is not being offered for the truth of the matter asserted, but only to potentially explain defendant's potential actions. And I understand you may not like this, but I have this as well. As with any witness, issues of credibility are solely within your discretion. To be clear, the court is not making comment on the evidence one way or the other.
just to be honest, I mean, that's more concerning to actually, just to bring in credibility.
Okay, what's your draft?
My proposal would be that you give no instruction at all. You just
I
say,
understand that's your position.
if you choose not to do that suggestion, which I understand the court is leaning towards giving an instruction of some kind.
Not to be argumentative, but 5 minutes ago, 10 minutes ago, I told you that I was going to give a limiting instruction. And
Yes,
I
sir.
appreciate any input. So your input is don't give one.
No, sir.
State what's your input. State what's your input.
I have no objection to your limiting instruction, Judge.
Back to defense.
I didn't mean to infer, I'm just merely trying to preserve the record. With
The record is so
respect
preserved. You object to a limiting instruction.
Yes, sir.
Now that I'm giving a limiting instruction, would you like to have any input?
Yes, sir.
And what would that input be?
The input is, I would like it to be limited in time, meaning so that the jury doesn't think that every single thing that comes out of her mouth is under this strange umbrella of credibility, and we're not sure if we believe it, and it all's
Well,
hearsay.
every witness's testimony is under that strange umbrella of credibility.
Sure, but we haven't told any of the other.
I've said it. We've had 3 or 4 expert witnesses. Every time I've had a version of believe them, don't believe them.
True for the experts you did. That's true, but none for the lay witnesses, right? That's my concern, and it's the defendant, which is obviously the most important witness, arguably, in the case. So my suggestion is just limited in timing. It just says the state's interposed an objection to hearsay. I've ruled this is non-hearsay, and that's the end of it. That'll be our request.
Crafting and True Crime with Jacqueline says, I didn't get to see all of this yesterday. I watched from almost the end of her testimony, then the cross of her basically about 10 minutes before the lunch break, aka all this. I didn't know what it was about. I kind of feel like this isn't normal. If we were live, of course, we would be seeing this just as it plays out. And yes, the advantage of playing it not live is you can skip all this, but this is like an important argument. And I'm not a fan of the defense attorney's approach. However, I do agree with his fundamental point. Okay. This is a self-defense case. What she's about to say is not hearsay because it's not offered for the truth of the matter. That I think that last part, it's not offered for the truth of the matter, can be confusing to a jury. And so what does that even mean? You know, what does that mean? Does that mean that a jury's not going to understand that? I mean, hell, I've watched 11 billion trials and I barely understand hearsay, and I definitely don't even know 1/8 of the hearsay exceptions. So I agree that this should be we should hear this. Did I say that wait. What? No, the victim is the most important part of the case, sir. Oh. Yes. The victim is the most important part of the case. However, this is a trial. And for the judge and for the defendant, legally, her right to a fair trial for the judge is the most important thing. So I think that if they do too much explaining and talking about and bring in hearsay and say that it's not offered for the truth of the matter, bottom line, I think it's going to be too confusing for the jury. I don't care for this attorney's approach, like I said, but I do understand and actually agree with his argument. Oh, I got you. Crafting and True Crime. Yeah, I got you. Gotcha. Just going to speed this up a little bit because we only have like a couple of minutes. The Nuggie is just so excited to ride her bike. hold on a minute. Let's see.
Jury comes back. The court has overruled the hearsay objection and rules that the answer is not for the truth of the matter asserted, but only to potentially explain defendant's potential actions. As with any witness, issues of credibility are solely within your discretion. To be clear, the court is making no comment on the evidence one way or the other.
I think that's as good as you're going to get, bro.
The same objection, Judge. And just to be clear, and I understand that the court's going to give it, and I'm not making a comment on that one way or another. After you give the instruction, I'm required to re-object, so after you do give the, I'm not asking to rehash this thing, I just mean for purposes of the record, I have to make a statement about restating our previous objection, and I'll just say it like that, and that's all I have to say about it.
Restating what previous objection?
That we do not wish the court to give an instruction as proposed.
All right. We've already let the horse out of the barn, and practice pointer, defense can take stands, usually a good time when the judge comes out and says, hey, is there anything to let the judge know? Dr. Mericle, you've already started testimony. To be clear, that horse is sort of already out of the barn. We could obviously take things, but it's my understanding you do wish to testify. Is that correct? Great. All right, come on up.
All right, so this is where we're going to end it for the day. Okay, thank you guys for understanding and always giving me grace where it comes to the nuggie. So we have a big day for tomorrow. Oh, you like that emoji? Crafting in True Crime. Guess who made that for me? The incomparable Neat Noodle. She made it. I love it. It's my favorite because I call her Chicken Nugget Pot Pie Esquire. So yeah, she made that for me and I love it. Thank you guys so much for being here. We're going to pick this up tomorrow and hear her testimony. Unfortunately, I think we might have to do it without closed captions. I don't know, because it is a 10-hour long day and I doubt that they're still processing. I mean, it's possible that it could be. So hopefully, fingers crossed, we'll see them tomorrow. All right. You guys have a great rest of your afternoon. I'm going to go ride bikes with the Nuggie, and I will see you all later. Don't forget, this weekend, Saturday, we're doing a recap / deep dive in the Christopher Preciado trial. Remember, he is accused of murdering Savannah Soto, who was pregnant with her son, Fabian. The baby's father, Matthew Guetta, in 2023, December 21st, 2023, to be exact. So if you're interested, if you followed that case and you want to catch up on what's been going on in the trial and all the goings on in between before we even got to the trial, tune in on Saturday. The live is already scheduled. It's on the upcoming lives section. All right. You guys have a great rest of your day, and I'll talk to you later. Bye.